Open this public hearing of the Joint Standing Committee on the implementation of the National Redress Scheme. I acknowledge that where we meet today has been the meeting place for the Ngunnawal and Ngambri peoples for thousands of years. I acknowledge the cultures of any Aboriginal or Torres Strait Islander people that will be present with us today. In accordance with the Committee's resolution of 8th of September 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcript of the proceedings will be published on the Parliament's website. Right, just let me work out where I'm going next with my paperwork. I now welcome Jane to give evidence today for the Committee's inquiry into the operation of the National Redress Scheme. Anyone observing these proceedings is advised of the following. The Committee has ordered that the name or identity of this witness must not be reported or disclosed. The Committee has ordered that third-party filming, recording or photography of the witness is prohibited. Official broadcast is available. Disobedience or breaches of these orders would be a serious matter and severe penalties could be imposed. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I ask all witnesses to respect the privacy and to refrain from naming or identifying individuals as being victims or survivors. The Committee can hear evidence in private session if necessary. I now invite you to make a short opening statement of no more than 5 minutes before we proceed to discussion. So, Jane, would you like to make an opening statement?
Look, I often talk about courage to my children, and I think today I need some, so bear with me.
We will.
I have made a submission to this committee, and I believe as of 2 days ago it might have been uploaded to the website. I thank the senators and the members of Parliament for listening to me and for inviting me here. I think I'll simply say that I was placed in state care as a young person after a severe illness. The committee knows what that illness was and has information regarding a long history of medical illnesses. I was placed into care voluntarily by my parents at the behest of some people who were involved in my case management at the time, including a worker at the children's home, which I was to first be placed and was subject to this redress application. I was made a ward of the state the following year after entering into care on a voluntary basis through it was a voluntary arrangement with my parents. The state always had care and custody of me, and guardianship moved the next year. I remained a state ward until I turned 18, whereby I moved state to attend university and to leave my past behind me. During my care years, I spent a lot of time in church-owned and state-owned facilities, and this time was marred with unhappiness and abuse perpetrated by both other young people and staff members. Young people were powerless in what they could do to assist their situations, rarely being visited by departmental officers. I would say that in the 90s there was no place that was safe for me. I was abused in institutions, I was abused in the hospital, and I was abused on the streets. Often I'd opt for the streets, not because it was fun or exciting, but simply because I felt I had more control over my life there. And in the sense of control, I met some really bad people, but, I could wander around in peace. I made an application to redress in good faith in 2020, right before my husband took his own life. He was also a child abuse survivor. He had been raised in institutions in Queensland. We bonded over that experience when we were both obtaining our qualifications, and I think through his life, he identified as Indigenous. He struggled outwardly a lot more than I did, but we rarely spoke of our experiences, and I certainly never spoke about them to anyone who I met or came into contact through a workplace. I was always very scared of exposure and what that would mean for me, and I know at times when exposure has been somewhat present, it certainly hasn't equated into being viewed with kindness, is what I would say. So in 2020, right before my husband died, I had a diagnosis of an aggressive melanoma, and a girlfriend who was very bright administrative lawyer was talking to me about her work in redress and asking me often about my opinions. We would sit at night, talking about the matters that she had, and more in a generic sense, but she was trying to make sense of what the scheme was about. She felt that there wasn't consistency in decisions. She felt that there wasn't adequate training. She felt that IDMs were given 2 days of training and they were making very significant decisions about people. But she mainly felt that most decisions were going through to the keeper, including in matters whereby, the abuse in itself just wasn't proved and there was indication that it didn't happen. I remember talking to her one night and saying to her, is it really a bad thing that for the first time in the history of this country there might be something like a scheme that followed a royal commission that tips the scales in the favour of a claimant, noting that compared to common law damages, the scheme wasn't dishing out a huge sum of money. And she was very much of that view too. I think she just felt that there was a lack of process, and she raised that institutions were getting really cross with the work that they were doing. One night, my husband, who I was separated, we were separated, but I had full custody of our children. He went missing, and she came to see me because the police had been involved and there was concerns about his mental health. And she basically said, from the outside, you two look really together, what's the story here? And, I'd known her for nearly 20 years, and I said, the story is that we were both child abuse survivors, and this is my story, and his story is his story. And I told her a little bit about what I'd been exposed to as a young person. And I think she was just totally floored that I'd managed to kind of work and go through systems and employment, and she had no idea about this. And she basically talked me into, over about 2 weeks, making a claim for redress. And I think I felt at the time that our lives were once again quite precarious. Things were shaky financially, and I had this diagnosis, and the wheels were coming off for us a little bit, or a lot. And so I decided to make the application on a set of abuse that had happened to me in care, but had gone through to a prosecution. Part of the chain of abuse, there was criminal conviction. So it was clear the abuse occurred. The abuse was perpetrated by a much older young person in the same care facility as me. And I put in my application. 14 months passed. My husband was found dead a month after my application was submitted. I recall the redress scheme rang me about 3 days afterwards, and I said, oh, look, we've just had the most horrendous thing happen to us. Can you get back to me in a couple of weeks? And I believe they did. But 14 months after that, I hadn't heard a thing. So I contacted the then Secretary of DSS, Catherine Campbell, and straight away a very pleasant young man rang me to basically say, your application's looking good, sorry we've left it so long, I'll check in with you again next month, and, thank you for talking to me. And I hung up the phone thinking, oh, what a pleasant young man, and, it's all under control. The 12 months they said, they're just going to take a little bit longer. Sorry, now I'm really going on. I'm going into the history. Post-September...
Really
Thank you.
And so please just take the time you need.
Thank you. So I think I got another check-in call from him the next month, and nothing untoward. And then in September 2021, so this is 15 months after I'd made my claim, I received this out-of-the-blue phone call from someone I didn't understand very well, who seemed to me, having been a career public servant, as someone very junior. She told me my claim had been rejected. And I tried to explore a little bit with her the reasons, but I was quite shocked. And she basically said to me, "Oh, you were in the care of your parents," and that just hit me with a. How could they ever conclude that? After I entered care in the early 90s, I never went home to my parents. I was in care till I was 18. And then she said something about it being that my guardianship was with my parents. And I was like, well, you can't have a two-tier system where guardianship, kids who are abused in institutions who have a different court order to other kids aren't compensated. And so I hung up the call feeling like she actually didn't know why my claim was being rejected. Like even, we weren't even 3 or 4 questions down the pathway, well, 1 or 2. And we weren't getting anywhere. So I hung up the call. I wrote to the then Secretary of DSS, Ray Griggs, saying, look, I have an indication, but I have no idea why, that my claim is going to be rejected or is rejected. And what occurs from that point on, I think, is my real gripe with the scheme. So Mr. Griggs responds to me and he tells me that it's not been rejected. I get this period of, I can put more information forward. I'm not super keen to do that, to be honest. I'm feeling like, my life's under a microscope. These are people who potentially I could work with. I know that people I have worked with have gone to that department. I'm feeling a little bit stressed, but over the next couple of months, and I believe this is the time when departmental staff are communicating with each other that my claim was always going to fail. And, the next few months is just more of the same, except that I believe the department put out further requests to institutions that were barely related to my claim for more information. I get a couple of phone calls from a woman who I only know as Trish. I find those conversations really, really difficult, really, really traumatic. She's asking for details. She's coming at me. She's not particularly trauma-informed, and I've heard that word so many times, I don't even know what it means. But in the end, I get a decision a couple of days before Christmas in December 2021 that my claim has been rejected. At this point, I think it's been 20 months. I write to the secretary and say, can you give me the reasons? Because I get this letter and I've got a real problem with the letter that's sent. The letter that's sent says, we understand you were abused as a child. We're really sorry about that and you're not getting redress. And I think if anything could change out of this process, that letter should simply be, we've reviewed the material relating to your application and you're not getting redress. I think it's incredibly patronising and incredibly awful for a person in my situation who went through state care in the way that I did to receive that sort of, bureaucratic ministerial response that's been designed by people who I believe wouldn't have experienced anything like what some of the people who apply to the scheme experienced. Secretary Griggs assures me that I've been sent my decision. I applied for FOI on communications regarding my decision and information about my decision because I actually didn't receive my decision and I don't know why my claim's been rejected. I'm offered an appeal process, but the problem with an appeal is if you don't know the reasons for the decision, you can't put forward the material to respond to whatever, the decision contains. I park it for a little bit, and then when I'm on the eve of the appeal period expiring, I do appeal, noting at this point I'm in a very senior role in a very well-known firm in the country on a pathway to partnership. I know that my appeal is going to be rejected because I couldn't put forward anything to counter the decision because I didn't have the decision, so of course my appeal is rejected. I think I write to the secretary again asking why my appeal was rejected, and I don't receive my reasons for the appeal being rejected either. I park it all. I resigned from my job. I spent 8 months grappling with the fallout from the redress application, you know, the inability to sleep, the sense that my life has just never been what it should have been, you know, that I'm always almost there, but I'm not. By this point, I have instructed lawyers to look at a civil application through the courts, knowing that that's in my hometown and that there will be people I know that will be involved with that process. But I feel basically that my redress experience has blown up my life, so it couldn't get much worse. I spent 8 months unemployed. I make an application to access my super so we don't lose our home. And I get back on track. I go back to doing a job that I loved, and I was very well supported in the same portfolio, actually, as the redress scheme. I think that's where I should possibly pause, noting that preparing for this committee appearance, I start to go through some of the material. Nothing was released to me on FOI. 20 documents were identified, the secrecy provisions, deliberative processes, all sorts of exclusions were claimed as to why I couldn't have my own material. I then realised that there is a decision, but it's been withheld through the FOI because of, they say it's a deliberative process, and because it's a draft, it can be withheld from me. My understanding is if it was the formal reasons, you're not allowed to claim FOI exemption as a department over those. And I realise there is material that hasn't been disclosed because in a couple of documents that aren't heavily redacted, there's a lot of staff chatter, including some very senior staff members talking about my case. And those messages in themselves weren't offensive, but they were very blasé, you know, like, howdy, tar, my phone is choking, got to get this to Ray, you know, and just not what I would have expected in this space. I write to Secretary Griggs again, and he comes back to me and says, actually, you've never been provided with anything. We've let you down at every point in this process. Here's your decision, here's your statement of reasons, here's your appeal statement of reasons that have never been provided to you. Here's some FOI. We're not providing you the institution's material because that's protected under secrecy provisions, and I'm not of the view it is because it's material that relates to me. And I think the Act provides that the secrecy provisions don't apply to material relating to the person as an exclusion to providing it, but I still don't have that. And here we are today.
Thank you, Jane. Thank you so much for appearing, for your submission, for all the work over many, many months you've put into trying to get a response from the department. I was going to ask you before you gave your evidence, you know, how your interactions with the scheme were and how would you describe their performance in terms of being trauma-informed and culturally, you know, a culturally safe organisation. I'm reading from what you've said that, well, you said you didn't find it trauma-informed.
So, Senator, I understand that the young man that I spoke to, who I thought was very pleasant, then went on into in chats with other staff to talk about me as not a happy camper, and my tone being, I'm very calm, but I have a menacing edge to me, and things like that.
Yes, I did read that.
Yeah.
I was horrified, to be honest, when I read that.
And so was I, because I applied in good faith to this process. And in the FOI, they released to me that 15,000 claims have been awarded for people who are not state wards and who are not in institutionalised care. I was both those things. In the ultimate decision, the IDM, and this is a decision the department frequently refers to as watertight, in the decision, the IDM finds that I was abused at a different date to the one I said I was, but that's okay because I'd been reunited with my parents. There's no basis for that conclusion at all. Like, I'm lost as... I wish I had been reunited with my parents, because my abuse was only to get worse post that date. A different set of abuse that, as you'd be aware, the state government has approached me on a compensation basis, but the process was so flawed, and the decision itself, this watertight decision, nearly everything she concludes, there's not a basis for the conclusion. And because I don't have the material from the institutions, I just don't know how she could have come up with, or he, sorry, I don't know, their names blacked out, how they could have come up with that. We've
You're
lost
on
you,
mute,
Senator.
Katrina, you're on mute.
Sorry, Sarah, Jane, sorry. You haven't been able to get any information in regard to the institution's response to the department's questions, is that correct?
That's correct. They've claimed the secrecy provisions, and if you read of them, I don't know what you think, but my reading is either I or the institutions can consent. It's an or, but the provisions don't exclude disclosure to the person to whom the information relates, which is me. But I'm assuming DSS has had that legal advice that, they require the institutions.
Well, we might actually ask them if they've had legal advice and ask for a copy of it when we next talk to the department. So I'll make a note of that and make sure that we do that. Look, we could probably take all day just to speak with you, to be honest. And still, have questions to ask, but I'm going to throw to Senator Smith. Is Senator Smith on the line?
No.
No? Okay, I'll throw to Senator Shoebridge first, and then Mr. Zabby. And Miss Archer, have you got questions?
Yes.
Okay, I'll make sure we get time for you too. So, guys, time's a bit limited, as you know, but if we could keep it concise. Yeah. That would help me in chairing.
Senator
Shoebridge, you've got 5 minutes.
Oh, thanks, Chair. Jane, first of all, thank you so much. And far from you appearing with a menacing tone to you, you appear in the face of having all of that trauma and having, where you are, this extraordinarily strong position you are after all that trauma. You strike me as intelligent, informed, and calm, and
very articulate.
And so when I read the way they judged you, I'm insulted on your behalf, and I just want to apologise to the extent that we're in any way connected with this scheme for the way you were treated. Utterly wrong. Could I ask you? Have you concluded your FOIs? Have they provided everything they say they're going to provide to you?
I believe they have. Yes, I believe they have, but heavily redacted as...
Yep. And in fact, as you see now, when they were saying to you over the phone that, it's on track and your decision is, you can look forward to a positive decision, it seems they knew at that time that they were going to deny it.
Absolutely, and the fellow that made those overtures to me wasn't the one that placed the call for foreshadow rejection, which was, at the time I was a bit confused. I was like, I thought I had this person picked by the secretary to be my, conduit, and he has not made this call. And in fact, in his message, he says he gives a heads up to the IDPC call that's coming, And whatever that heads up wasn't included in the FOI material to the governance area, I believe he suggests. So.
And when you look at the messages they sent to each other after you speak to them, okay, do you know if there is a way to pull the call recording for that one? Like they're investigating you for your behaviour.
Well, my understanding too of that call was that I wasn't I wasn't advised that it was recorded, the IDPC calls, so I was actually walking with my daughter in a horse paddock when I received it, and it was just out of the blue, like there was no, and I didn't know.
No message, you're going to get a call, we're going to talk to you about a deeply traumatic part of your life, you just get a call.
And it's recorded. So I'm being recorded in the moment of my, I don't remember how I responded exactly, but I do think I was a little bit angry because she couldn't answer my questions.
Jane, sorry, you get a call out of the blue without any preparation that your claim had been rejected. They record it without telling you, and then they judge you for your response. I mean, I can't imagine a less trauma-informed process than that. And again, I cannot believe it happened to you. And I just, to the extent we can, I think all of us apologise. I can't believe that happened.
And without making that personal, like the secretary and one of his very senior people kept, because I wrote to ministers and I wrote to wrote back and said, we're trauma-informed, your matters being handled with the utmost sensitivity. But it was the secretary himself that maintained to me a number of times that I'd been sent the reasons for my decision, to the point where I thought I was going quite mad because I was...
It's almost like they're gaslighting you. Just whatever they say, whatever, without any due diligence, without checking your papers, without checking your files, without thinking about you as a human being.
And it's funny, Senator, because Grace Tame talks about that, and Grace Tame was Australian of the Year in the year that my redress decision was decided. But she talks about the institutionalisation of gaslighting survivors, and I agree. Like, I remember scouring my laundry for additional papers because I...
Maybe you'd thrown it in the...
Yeah, maybe I'd thrown it in the bin. But, this one paragraph to prepare for the appeal to the department.
And they never challenged the fact of the awful abuse you went through, and I won't repeat it, but I've read your submissions, and they never challenged that. So they know the degree of trauma you've had in your life, multiple layers of trauma. And then when I read these messages and they say, please keep me in the loop there, she hasn't been the happiest camper on her check-in calls. I can't imagine any department, any agency whose job is to deal with survivors who have been through traumatic experience dismissing you like that.
And it's funny you mention that because I work for an agency now that cops a lot of flack, but the person I report to and his boss, I was concerned I'd lose my job because, I've come to a parliamentary committee and I'm complaining about a parliamentary process. And without any concern for themselves, they actually said to me, we back you. We
treated you like a person.
Absolutely.
Senator Shoebridge, we're going to have to move on because time is of the essence.
Could I just, for utter clarity, you have since stepped outside the redress system and you're in the process of resolving your civil claim on vastly more financially advantageous terms, which I would suggest is a very clear indication of the bona fides of your case. If you had a message to the secretary and the bureaucracy who dealt with you, what message would you like to give them?
It's the bureaucracy. Like, you can deal with people using guidelines and rules and, let's forget the trauma-informed. I would have settled for some respect. But you need to have a heart in some of the things that you are doing and how you're doing it. But I think I would say that I came from a background where the public servants had integrity and honour in serving their government, and part of that was their forward-facing to the community and the public. And I would like to see some of that restored, especially when you're dealing with, and I think it was almost criminal, that second tranche of, going after information about me and how it was dealt with. But you need to have some sort of humanity in the way that you approach people and decision-making, even because you can do so and still be within the confines of the legislation and the policies and, bureaucracy protects to a certain extent, but it doesn't explain, I think is what I would say.
Thanks, Sue.
Senator Shoebridge, I'm going to move on to Miss Archer now, and then I'll come to you, Mr Zapier.
If you've got time, Katrine, but if not, it's
sorry?
okay. If you've got time, if not, I'll... Yeah.
Okay. Yep. Miss Archer.
Oh, thank you. Thank you, Jane, for your submission today and your courage. And I'm very sorry that you have had to do this. I guess my line of questioning follows on from Senator Shoebridge's in terms of I'm just struck from your evidence by how little support seems to have been afforded to you on the way through this process. And I guess I just want to tease that out a little bit in terms of what more could or should be done to provide support for people undertaking this process.
I think a quick triage system would assist in the sense that if they really feel that someone's going to fall outside redress, and I'm still not clear why I did when they've made 15,000 decisions contrary to mine, with far less, as Senator Shoebridge has pointed out, evidence or clarity around care arrangements and things like that. I believe they opted for a technicality when it came to me, but a quick triage to see if people want to keep going down that process, because what they led me down after September 2021, where staff were clearly of the understanding I would not be eligible for redress, and the people they contacted to provide information about me and the additional agencies was beyond the pall, and it wasn't something that I would have consented to, and I didn't consent to in my mind. I was really reluctant, but I think if there's an initial triage, and I know that other agencies are setting those sorts of processes up in semi-judicial matters, whereby someone can have an indication, that would be a really good idea. As a manner to, yeah. And I think what could fall out of this too would be some sort of look at that departmental culture, because in my experience, people don't just start talking like this. Like, that's reflective of something that's been allowed to manifest, and people in senior roles not pulling other people up. And I do note that the Secretary himself referred to potential communication with me as walking into a minefield blindfolded. And I think it's statements like that, filtering down that, yeah, it's where you get, some pretty poor processes cropping up.
And if you knew that this was what the experience would be like, obviously with the benefit of hindsight, would you have commenced this process in the first place? Oh,
not a chance with the civil matter either. I started down the civil route when I realised that this wasn't going to happen for me, and it had already brought up everything that I'd spent 25 years, 30, 40 years burying, this has had an incredible impact on my career and my family. And, as I said, my husband lost his life because he was a child sexual abuse survivor. And you never make the same decisions as other people, and you go through your life, you're cloaked with a darkness and a fear of judgment. And I think for me, out of this process, all that fear was realised, because that's exactly what happened. People who didn't know me made decisions about me and in relation to me, and it is what it is, isn't it? It's human behaviour.
Thank you, Jane.
Thanks, Mitch Archer. Mr Zapier.
Okay.
You've got a couple of minutes if you've got a question.
Thanks, Katrine. Jane, can I add my thanks for you appearing before this committee? I mean, I read your story, and quite frankly, what you've been through is something that I would not wish upon anybody. From your experience, can I ask this? Are you aware of anyone else or any other people that have put in claims that have gone through a similar sort of process? I'm not sure if you've had a chance to interact with others, but...
No, I haven't. And I think often people would just scurry away to the shadows, which is what I did, until a very senior, wonderful woman in my life said, there's this committee, you should approach them because you might get a hearing and you might get, you know, something good might have come out of your... but I can imagine if you're, you know, still living an itinerant kind of life, or you're in a remote community and you put in an application... I don't know, but I guess what I could say is that given this happened to me and I had the Secretary's oversight for the most part of my claim, I could only imagine what's occurred in other people's redress decisions.
And just to wrap this up, and to be clear, you've now you're pursuing a civil case to get some redress, and the perpetrators have been found guilty of having committed the perpetration?
So in my claim for redress, the perpetrators were found guilty of those offences or offences that there was a course of conduct against me as a child in care by a person in care and people associated with her. I went through 8 years of criminal processes. Those matters didn't settle till I was 23, and one of the decisions went all the way to the Court of Appeal of New South Wales. In the civil case, it's still going. I had a large offer from the state government. Justice Elkheim last week said that the abuse that, if proven, was a massive assault on a young person that was persistent and pernicious. I'm hoping we resolve and, you know, we can close this chapter noting it's been 5 years nearly. Yeah.
Well, Joan, I wish you well in those proceedings, and thank you once again for appearing before us.
Thank you for having me, everyone. Thank you,
Jane, can I just say thank you again on behalf of the whole committee for the amazing submission you did, as well as appearing today. We do understand it's not easy. It's not just words from us. We really do understand that it's not easy for you. If you've been asked to provide any additional information, can you forward it to the Secretary by Thursday, 15th of August 2024? You will be sent a transcript of your evidence, and you will have an opportunity to request corrections just to transcription errors. So, you know, I hope that it's never going to ease the pain you've been through and to be frank, inappropriate behaviour by the department, which is, you know, we're just not going to sit and hear you today and not do anything about that. Trust me, we will be taking that up to the department, even if it means delaying our report. We will be, I don't care what the rest of the committee says as chair, that's what we will be doing. It's absolutely inappropriate. If it happened in my office, people would be sacked on the spot. So please leave today feeling a little bit better, and that not only for yourself but for other people that have applied that haven't maybe got the ability or the general feeling confident enough to come and speak to us, because you have made a huge difference.
Thank you,
so
Senator.
thanks.
I would just add that your secretariat has treated me really kindly.
They're pretty good.
Yeah, they're lovely. They are lovely. We're very lucky. Very, very lucky.
Thank you all for your time.
Thank you. Now, Andrew, I think we're going to suspend public proceedings until 11:15. Is that correct?
That's right. So I think you do need to move a motion to hear the next witnesses in camera.
Yeah. So can someone on the committee please
I'll do that.
The evidence and say sorry now be heard in camera? Thank you, Mr. Zapier.
Yep.
resumed. Lorraine.
Yes.
Welcome. Before we begin, could I please clarify whether you would prefer to continue using a pseudonym or use your real name?
I prefer to use the pseudonym, please.
Thank you. I welcome Lorraine to give evidence today for the committee inquiry into the operation of the National Redress Scheme. Anyone observing these proceedings is advised of the following. The committee has ordered that the name or identity of this witness must not be reported or disclosed. The committee has ordered that third-party filming, recording or photography of the witness is prohibited. Official broadcast is available. Disobedience or breaches of these orders would be a serious matter and severe penalties could be imposed. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I ask all witnesses to respect privacy and to refrain from naming or identifying individuals as being victims or survivors. The committee can hear evidence in private session if necessary. Lorraine, I now invite you to make a short opening statement of no more than 5 minutes. And can we just introduce the person with you? I presume that's your support person, is it?
Yes, this is Leonie Sheedy, the CEO of Clan.
Lovely. Thank you. And welcome, Leonie, to you too.
Thank you.
So it's down to you, Lorraine.
Thank you. I'd like to take this opportunity to add in further information and perspective on my sexual abuse experience at Bajura. Upon reflection, I now realise that when I recounted my experience initially, I was doing so from the perspective of an adult, trying to make sense of what happened to me as a vulnerable, innocent 13-year-old child. I feel that by writing my experience from an adult perspective, it has tainted the actual experience of sexual abuse for me, and this has resulted in an interpretation on the NRS part that this was just a run-of-the-mill medical procedure. This was the information provided to me upon hearing I was ineligible for redress based on my experience. I can see that in describing my experience, I have used assumptions of what happened to me and by whom instead of recalling what was told to me and what I experienced as a 13-year-old girl. I'm going to take this opportunity to rewrite my experience of penetrative sexual abuse at Bajura based on the information and knowledge I had at the time and not the assumptions I have made since as an adult. I was a 13-year-old and was charged with truancy because I wasn't turning up at school, as I didn't have money for the bus fares. I was put through the courts but let out on probation on condition I went to school. However, I didn't have books, uniforms or any money to get to school, so I packed my bags and ran away for 4 days to stay with my cousin. I was teased a lot at school for not having the right equipment, clothes, etc., and I couldn't bear the thought of going back. I'd broken my probation and my mother kept moving us around so that the Department of Child Welfare wouldn't find me. She kept trying to protect me. Initially, the Department of Child Welfare eventually the Department of Child Welfare caught up with me when we were living in Newcastle, and I recall the knock at the door. I had to go back to court with my mother and I was sent to Bajura. I was there for approximately 3 weeks before I was processed to be sent to Linwood Hall. It was during these 3 weeks that I was sexually abused at Bajura. Whilst there, I was told to go up to a room where there was an adult female present. Not long after, an adult male came into the room. Neither of these people were introduced to me, either by themselves or the staff at Bajura. The male asked me some basic questions about my health and then asked me if I was a virgin. I disclosed that I had been raped, to which the man replied, "You'd be a filthy little slut then." I was in disbelief that he said that after I disclosed I was raped. Neither him nor the female in the room showed any compassion or asked any questions about the rape. After disclosing that I'd been raped, this man told me to take my pants off and lay up on the table. He was cold and demeaning in a way that he spoke to me. The female still hadn't said anything. I did what I was told, as that is what I was taught to do at Bajura, so I wouldn't be punished. I tried to keep my legs together once I was up on the table, as I felt exposed and ashamed. Both the female and the male physically forced my legs apart. They then strapped me into something on my legs and feet so I couldn't move and my legs were wide apart. I tried to move to escape, but I couldn't. I was trapped. I wasn't given anything like a gown or blanket to cover myself with to have some sort of dignity. I was just laying there exposed. The male then proceeded to forcefully shove his fingers inside my vagina. He then put something metal into me which was sharp. It was so sharp I didn't know whether it was his nails, and it felt like it was slicing my inside. I told both it was hurting and asked them to stop, but they ignored me and continued what he was doing. I had silent tears coming down my face. He was so rough and I was in so much pain. During this time he called me a slut again and the woman didn't say anything. When he was finally done, he went and sat at the table and the woman told me I could put my underpants back on. I had blood running down my legs, and when I put my underpants back on, they were instantly covered in blood, so much so I had to ask for a new pair of underpants. I was in pain for many hours after this sexual abuse, and the bleeding continued for quite a while as well. I experienced a complete mix of emotions after this, but most of all I was confused, frightened and scared. I also felt humiliated and embarrassed and ashamed. I would like to point out to the NRS that at no stage was anyone introduced to me as a medical professional, and the sexual abuse that happened to me was at no time introduced to me as a medical procedure. There was no explanation given as to what they were doing and why. I was forced down and strapped onto a table. I did not give consent or informed consent to what happened to me, and my autonomy was completely taken away. Furthermore, the male, who was an adult, we assume was probably a doctor, proceeded to call me a slut when I disclosed I was raped. This is the furthest thing from any standard medical procedure that I can think of. Additionally, the male penetrated me so violently that I was bleeding excessively and in a tremendous amount of pain. A standard medical procedure should not involve this. I was treated violently and aggressively by the man because he viewed me as unimportant and as if I didn't matter and like I was a slut. If these actions were perpetuated upon anyone else outside a children's home, even by a medical professional, they would be committing a crime. Just because I was a state ward does not make me or my rights any less important. The trauma from this incident has carried me throughout my life. Not only has it affected my mental health, but I have suffered physical health issues as well. I've been diagnosed later in life with a condition called lichen sclerosis, which affects my genital area. The cause of this is unknown, but the symptoms involve pain, burning and itching. I live with these symptoms for a good portion of my life and didn't want to talk to my male doctor about it, and there was no way I would allow myself to be examined down there by a male doctor. I put up with these horribly uncomfortable symptoms for years because of what this man did to me at Bajura. Any legitimate medical procedure carried out in a purely medical way does not leave someone with the trauma, pain and bleeding that this did. It is unconscionable to me that this man could sexually abuse girls in this way, and the National Redress Scheme condones it. I urge you to see past the fact that these procedures were supposedly carried out for medical reasons, albeit medical reasons that were discredited even back then, and look at how it was carried out. There was no informed consent, there was no explanation of the process, there was no introduction of who these people were. I was forced down and strapped down and deprived of my liberty of choice. This was not a medical procedure. This was penetrative sexual abuse on a 13-year-old girl.
Thanks, Lorraine, for appearing today. Are you okay there?
Yep.
I think there's tissues on the table, and I'm sure someone will get you a glass of water if you haven't got one already.
Thank you.
Okay. Yeah. Please just let Nathan know if you need anything over the back.
I will.
More
Okay.
than happy to assist.
He's been terrific.
So,
Thank you.
yeah, great. I'm pleased to hear that. Not that I doubted it, but it's nice to hear
He
it.
truly is very helpful.
After the trauma that you've been through your life, I think it's nice when people are nice to you anyway.
Yeah.
Okay. And please don't take this the wrong way. I'm not saying that when I say just the once, but you were there for 3 weeks, did you say?
Yes, I was.
Clinic?
Yeah.
Did they only do that test once to you?
Yes, they did.
Right. Were you able to talk to any of the other girls there about whether they'd had to go through that sort of thing?
We didn't really discuss that kind of thing. You sort of kept to yourself as much as you could.
Yeah, I understand
you didn't
that,
share that kind of experience because, well, I suppose in a way we just assumed that everybody was subjected to the same kind of treatment.
It's also
and if you're only there for 3 weeks, you haven't really probably necessarily bonded with people.
No, that's right.
You were there for 3 years. You might have. They had that relationship, but I was just interested to see if anybody else had actually mentioned it or not in that time period. But I understand why they might not have as well. Yeah, and I really don't want to upset you by this, but have you got any idea how long the actual examination took?
Eternity. It felt like eternity.
Yeah, I understand.
I'm not really sure how long it took, but I know it just at age 13, it felt like it went on forever. And it actually felt as though I was being raped again, as I had from previously. Yeah.
And at no time did they say to you, we're doing this for medical reasons? Or
They barely spoke to me. It was like I was just there and, they were just going through the procedure and I wasn't...
You were just a somebody.
Yeah, I wasn't even important.
Yeah, okay. All right. I might have some more questions later, but I think Senator Shoebridge, you've probably got some questions, have you here?
Yeah, I do. First of all, Lorraine, that was an extraordinarily brave and strong statement.
Thank you.
And so sorry.
Thank you.
And I think you have some photos there.
Yes, I do actually. This is a photo of my mum and dad when they were...
Do you mind if I have a look?
Yeah, be careful. It's about to fall to pieces on me, actually. Oh, sorry. And this is my confirmation photo that was taken a year later. So
which one are you?
I'm the one in the middle there with the...
Cool.
So I'm a year older than I was at the time of the assault.
This is when you were 14?
Yes.
Huh. It's a gorgeous photo.
Yeah, that's taken in the front.
Is that up in Newcastle?
No, that's at the front of Linwood Hall in Guildford.
Thanks, Tom. Yeah, it's a gorgeous photo, Lorraine. When did you put your redress claim in?
22, I think it was.
And what happened?
They said that they considered it to be a medical procedure, and that they declined. And they said unless I could come up with some other evidence that
Good.
So
having an insulting, cold male, whether he's a doctor or not, insults you like that, treats you with disrespect, subjects you to such a painful procedure, I can't conceive of how any scheme could call that a medical procedure, Lorraine.
Well, neither can I, actually. It's, and also too, like the United Nations don't sanction virginity testing. And
It's a crime in the UK in every circumstance.
Yeah, if the United Nations doesn't sanction it, why does the Australian government?
Leonean clan have repeatedly described this as state-sanctioned rape, and I can't conceive of it as anything else. Lorraine.
I wave that banner. I wave that banner. Don't worry, it is. It feels like rape.
And how old were you when you put the claim in?
60. Oh, it was 50. 69, 68 or 69. Yeah.
So this is
because I'm 70 now. Yeah.
So you've been carrying this trauma with you for over half a century.
Oh yeah, definitely. Yeah.
And what were you hoping for from the redress claim?
Accountability. That's my main. I want somebody to be accountable for what happened to me, and to admit that what happened to me was wrong.
Deeply wrong.
Yeah, and it's the accountability more than anything. And I'd like other girls that were treated that way to be noticed, and to be. It's sort of hard to. It's hard to put it into words, but I want them to be noticed and for the government to take accountability, because I was a state ward. They took me off my parents.
Maybe to care about what happened to you as a 13-year-old.
Yeah,
to actually
exactly.
say that matters.
Yeah, that's right. And that's, to me, that's accountability.
Yeah, because it does matter, by the way.
Yes.
What happened to you does matter.
Yeah, you see, and my dad had committed suicide when I was 6, and I'd never, not really, I was in St Elizabeth's Girls' Home in Singleton when that happened, and my sister and I weren't allowed to grieve because because he'd committed suicide. They told us that he was a sinner and we weren't allowed to pray for him. So that had carried on, and I never, not being allowed to grieve for him as a child then, and then having this, I've just felt continually assaulted, if you understand what I mean. Yeah.
I think I have some sense of what you mean, Lorraine. I think I do.
Yeah.
If you could say, if you had this scheme sitting here, who rejected your claim, what would you want to say to them?
Basically, it might be blunt, but get in touch with reality. This is what happened to children that were in the government care, and now it's time for redress to acknowledge that the things that happened to these children are wrong.
But you knew it was wrong at the time. You don't need that perspective as a 13-year-old girl. You knew that was wrong at the time, didn't you?
Yeah, that's right. But why aren't people acknowledging that now? Okay. And to say sorry, sorry's a word, and that's all well and good, but prove you're sorry. Admit the fault.
Yeah. Can I tell you what angers me about the scheme amongst, refusing your claim, appalling. I can't imagine how they did that. But we've now had other women come forward and tell their experience who've also had their claims rejected, and randomly women get believed or accepted. Randomly they're rejected. Mm-hmm. What I find extraordinary is the scheme has not changed anything as a result of the evidence that we've heard. They haven't changed.
Yeah, there's something I've always told my husband. We've been married for nearly 53 years, and he and Clan have stuck by me through all these little problems that I keep having, my husband said to me, "What do you want?" I said, "Oh, well, if I get money, well, that's fine, you know, because hey, we'll live without it. We live without it now. What's the difference? So much." But I've always said to him, I want that little piece of paper that says, "We're sorry, we were wrong," and it's the apology and the acknowledgement of the wrongdoing against me.
And Lorraine, from my perspective, you not only deserve that apology and that validation and that recognition, the scheme is designed to give you some kind of financial assistance too. Not full compensation, but that's meant to be part of the system acknowledging what happened to you as wrong.
A bit of counselling and it all costs money.
Maybe you and your
obviously.
husband can go on a trip to Fiji together, take that piece of paper with you. That would be nice too.
No, I think
you're owed that kind of thing.
I think we're finished travelling now because I fall over all the time.
But Lorraine,
Senator Shoebridge, I'm going to have to move on because
Cool.
I know Miss Archer has got some questions. If we've got time, I'll come back to you. So, Miss Archer.
Thank you, Lorraine, for coming today and for your courage and sharing that really powerful story with us as well. I just wanted to ask you about support and the support that you feel has been provided or not been provided on your way through this journey. And you mentioned that you've had some support from Clan and from your husband, and I'm interested to hear about that support from Clan as well and what might need to happen to provide more support to people, either directly through the scheme or through support to people like Clan.
I think for counselling services to be provided and financially assisted through Clan and probably financial assistance to Clan itself, because the more people that learn about Clan and the services available, the more people that can be helped. And the Australian Orphanage Museum, that's helped people to recognise the problems that people suffered as children, just not only for I call it state-sanctioned rape, sorry, but not only for that, but for the cruelties and the trauma that happened to us all as children while we were in homes and so forth. And I feel the government could assist us greatly in that. And my husband, well, he did 20 years in the army. He's sort of learned to how to look after me by now. And we've been married, as I say, we've been married for nearly 53 years. So, yeah.
And what about your experience with the scheme itself as you've been going through this process and when you have had that rejection? What support has been provided to you from the redress scheme?
None. Sorry, none at all. And if I was asked, I would say, if somebody said to me, would you apply for redress again? I would say, never in a million years. It's suffering constantly from the beginning to the end, that it tears you apart emotionally, if not physically, and it affects your entire life, your children, your family, the people around you, in that you just constantly feel that you need support to get through the everyday things that other people take for granted.
But you've had to go and get that support yourself elsewhere.
Yes, I have, and that's why it's part of why I joined Clan in the first place, because they can help me. And without Leonie, we'd all be down the drain. I'm quite serious here.
Thank you very much, Lorraine.
Thank you.
Thanks, Mitch Archer. Lorraine,
Yes.
did you ever receive a clearly explained reason for the decision that the IDM's made?
Only in a phone call. I've never had it written or a letter to explain why and what. I was simply told on the phone that it's considered a medical procedure. And Leonie was on the phone as well at the time, and I broke down in tears. And when they couldn't get through to me anymore, my husband just said, I'm going to have to hang up now. So, but that was it, just told that it was a medical procedure.
So they never put it in writing to you?
No.
Never offered you counselling even though you'd broken down?
No.
Oh, dear me. Yeah, okay. And without traumatising you, what happened after that?
I went very quiet for a couple of months. I didn't contact Clan. I didn't contact anybody except I just turned inwards. And my husband is a little bit bitter about that because he doesn't feel that I've been... When we married and he knew about my past, he made me a promise that he would do everything in his power that I would never be hurt or upset again unnecessarily, and he feels in himself in a way that he's let me down in that way, even though he hasn't, because there's no way he could prevent that, but he feels that I should have been treated better.
And you obviously think that the decision makers got it wrong. From your evidence, trust me, I agree with you. Okay. How do you think, though, you can't make people be empathetic. So how do you think we can make the department more accountable? You know, do you think it takes training from departmental people, or do you think it takes something else?
I was just about to say that I think better training for the people that are reading the applications, and possibly, and I know it sounds like it might be a little bit one-sided, but maybe people that have been in contact with other people that have had these problems, and to recognise virginity testing as a crime instead of just that's something that happened when they were little.
In those days.
Yeah, in those days. And it's like a lot of things, like, the things that happened back in those days aren't politically correct, or they're not even legally correct these days.
Yeah, absolutely.
Lorraine, they were wrong then too.
Yeah, exactly.
And so many people knew it was wrong then too, and they knew that there was no legitimate medical basis for it. And that's what the guidelines should say. They should say, we knew it was wrong then, we know it's wrong now. That's what the guidelines should say. They shouldn't put you through having to explain how it's wrong.
Yeah, because when you apply for redress, you have to go through all the little details and relive the experience where even some of the things that happened to me, my husband of 50 years didn't know some of the things that happened to me, because you bury them because you don't want to...
Yeah, I was just going to say that.
Yeah.
And it should not depend upon you using some sort of unknown magic form of words to whether you get redress for this abuse that happened to you.
Yeah.
And it is just... I find it obscene the way the scheme operates, Lorraine. I genuinely do in these instances.
Well, see, there's a lot of these children that were in homes like I was there for truancy, but I had the advantage that when I was 29, my husband said to me, do you want to go back to school? And I said yes. So I went back to school and completed my education. But a lot of these children didn't have that opportunity, and so they haven't got the education or even the experience of those kind of things to be able to put their case forward better than they have.
Yeah. Mr. Zapier, have you got questions? Sorry,
No, thanks, Chair. Just a couple, and Lorraine, can I add my thanks to you for appearing before us and telling your story? It's so important.
Thank you.
Did you ever find out who the purported doctor or person was?
No, he was just the man upstairs, and I was really scared at Bajura too, because when I mentioned that my father committed suicide when I was at St Elizabeth's Girls' Home, the person in charge of St Elizabeth's was Sister Upfold, and when I went to Bajura, she was now Matron Upfold, and I was scared of her as a 5-year-old, and I was scared of her as a 13-year-old. So you didn't poke your finger into too many holes to find out what was going on if you could avoid it. And I remember once I had to deliver her breakfast to her on a tray, and I just ran up some stairs and hit the door and left the tray at the door and ran for my life, because she wasn't. Apparently she went to school with my father when they were young.
And are you aware of any other young girls who were treated the same as you?
There's constant, pretty much, well, from what I've heard, I can't say names or anything like that, but from what I've heard, everyone at Bajura went through that process.
When you say from what you've heard, did you ever speak to anyone else that reported the same procedure taking place?
Yes, I had a very good friend she's passed away now, but and we were still friends when we were in our 50s. Yep. And there's been other girls that we continued into our adult life, and we had all gone through that process at Bajura.
And just on the off chance, do you know if any of them had put in a claim for redress?
The one that I said has passed away. I'm not sure if I think she went through a private solicitor, but she received payment and acknowledgement of her trauma and suffering.
From the redress scheme or
from the courts? From the courts. Yes.
Yep. Okay. I think it pretty much. Sorry. And my last question was this: when you got notification, and you said that they said that was a medical procedure, did they provide you with any evidence that it was a medical procedure? Did they say something about it was performed by Dr. So-and-so or whatever that indicated that they had done some homework to determine who had done the procedure?
No, nothing. They just said, we consider that to be a medical procedure.
Okay,
and that was my answer. Yep.
Thank you very much, Lorraine.
Okay.
Lorraine, for the record, can I just say thank you to the Leonian clan for the support they've given you?
Yeah, I'd have been lost without it.
Yeah, and also not having met him. Mm-hmm. Your husband seems like a good egg too. And
yeah, he is.
Yep.
That's why I've kept him around for so long.
Yeah, well, a good decision.
He's a Tasmanian.
Oh, well, you can't have everything. You can't have everything.
The chair's Tasmanian, Lorraine, so obviously he's a great guy.
Yeah. Well, he went to Glenorchy High.
He went to where?
Glenorchy High School.
Oh, Cosgrove.
Yeah, Cosgrove. He lived at Glenorchy. Yeah.
I live near Cosgrove.
Oh,
yeah.
That's good. I visited there.
Tassie's a small space.
Yeah.
We better stop there. Might work out that I know him.
That'd be frightening.
Is there any more questions from anyone? No? Okay. Well, Lorraine, can I once again thank you so much for appearing today. Leonie, thank you to you too for being such a good support person and being with Leonie today. I'd like to say it's been a pleasure, but it's not a pleasure discussing this sort of stuff, but you've been very generous in your giving your evidence and opening up to us. We do really appreciate it. We're not cold-hearted people on this committee. I think all of us are very genuine about the concern and what's happening and making sure we can improve things for people. So thanks for that. If you've been asked to provide any additional information, please forward it to the Secretariat by Thursday the 15th of August 2024. You'll be sent a transcript of your evidence and we'll have an opportunity to request any corrections to the transcript errors. And with that, I'll say thank you, Lorraine, and I'll call Tracy Oldham.
Can I thank you for the opportunity to come and speak to you?
You're very welcome. Thank you.
Thank you.
We'll just clear the room, Tracy.
Okay.
I can't. Okay. Sorry, I'll just sort my notes out here. I have to go through some legal stuff, so I'll do that. Welcome, Tracy Oldham. I welcome you to give evidence today for the committee's inquiry into the operation of the National Redress Scheme. For the Hansard record, could you please state your name and the capacity in which you appear before the committee?
My name's Tracy Oldham. I'm here to request the National Redress and the Australian Government to formally recognise voluntary placement survivors as care leavers.
Thank you. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I ask all witnesses to respect the privacy and to refrain from naming or identifying individuals as being victims or survivors. The committee can hear evidence in private session if necessary. I now invite you to make a short opening statement of no more than 5 minutes before we proceed to discussion.
Okay. My name's Tracy Oldham, as I've just said, and I've been a lived experience survivor advocate since 1986. That's 38 years of my life spent advocating for the rights of everyone who's been wrongfully denied justice, including myself. I've been reaching out to senators and members of Parliament for more years than I care to remember, pleading with them to help me realise my goal of having voluntary placement survivors recognised as care leavers, all to no avail. I'm grateful to the few MPs who have acknowledged me, in particular former member Tanya Maxwell MP and Michael O'Brien MP, who sponsored my e-petition for legislation. I'm here today in solidarity with all past and present survivors of voluntary placement, demanding that as survivors of abuse, we be granted the same rights as wards of the state, and that the National Redress and the government stop their unjust discrimination for us simply because we were not institutionalised. Trying to explain the unfairness and the injustice we feel to those that have never heard of voluntary placement is one of the hardest things a survivor can do. For those that don't understand or have never heard of it, I'll just give you a brief outline. The term voluntary placement meant parents were able to hand their child over to a friend, family member or a stranger for care. There wasn't any real requirement. You could just palm your kid off to anyone. Shockingly, when a parent left their child to be in care, no court orders or paperwork was required by the government. The child was simply handed over to whoever was willing to care for it without any kind of government involvement. We were lost and forgotten by a broken government system that let us slip between the cracks until there was no trace of our time in care, because there was no government agency monitoring the welfare or whereabouts of voluntary placement children. As an avid genealogist, I find it difficult to accept that non-wards have no documentation of the time spent in out-of-home care, particularly as I've amassed an enormous quantity of vital records about my ancestors dating back to 989 AD. Despite being born in the late 20th century, there's no documentation of my time in care. In hindsight, perhaps it would have been prudent for the Australian government to employ Benedictine monks. Perhaps then we'd have a more comprehensive archive today. Because
Sorry.
Yeah.
Sorry. No, go ahead. Sorry, I wasn't sure if you'd finished or not, so go ahead.
I was taking a brief, sorry.
Yeah, no, it's fine. That's fine. Go ahead.
Because voluntary placement survivors are excluded as care leavers, we are not entitled to the same support services as state wards. As a result, we're left with no means of support and are left to deteriorate untreated and unhealed. We cannot access national redress as they only accept institutional abuse survivors. Open Place, which is now Relationships Australia, will not accept applications with no paperwork. Lawyers will not accept cases if you have no paperwork, tending to have preference over institutional abuse, because as I will tell you later on, they are guaranteed an income. Over the years, I have submitted and published numerous submissions to the Criminal Justice Inquiry, the Mental Health Commission, and the National Redress, not to mention a multitude of organisations, in an effort to raise awareness to the Australian government's flagrant disregard for voluntary placement survivors who suffered abuse in out-of-home care yet are still excluded. I've also included references in each submission that highlight the numerous inconsistencies in the official definition of a care leaver. According to the Australian government's own social services policies, children placed in institutional and other out-of-home care up to the end of 89 are referred to as care leavers. So once again, I will ask, why does that exclude us? Voluntary placement survivors are the invisible generation who sadly represent a generation of forgotten Australians that remain unseen and unheard by the Australian government to this day. Refuses to recognise us as care leavers despite being fully aware of our time in care. Sadly, I belong to the invisible generation, and as a voluntary placement, I endured some of the most horrific acts of cruelty that a child could experience after being abandoned and left to be raised by sadistic, unstable foster parents and repeatedly raped as a child by sexual predators. As a victim of abuse, I've never felt more invisible than I did on the days I attended both historical abuse apologies as a voluntary placement survivor. In 2018, I sat and listened to the former Prime Minister Scott Morrison say, today we are sorry. We are sorry that you were not protected. We're sorry that you were not listened to. We are sorry for refusing to retrust your words as children and for not believing you. We say what happened was not your fault. We are sorry that perpetrators of abuse were relocated and shielded rather than held to account. We're sorry that the records were destroyed. The Victorian, in 2024, the Premier of Victoria, Jacinta Allen, also apologised to historical abuse care leavers in Parliament, saying, to those children who were abused and neglected during their time in care, we humbly and unreservedly apologise. We failed you. We feel deeply sorry. I cannot express how deeply hurt and offended I felt when, despite years of repeated petitions and submissions to Parliament outlining my cause to have voluntary placement survivors recognised as care leavers, both these leaders still failed to mention voluntary placement survivors. We were literally snubbed. Voluntary placement survivors have always been overshadowed by institution state wards who've received all the attention and publicity while voluntary placement survivors are continually overlooked, even though we lived in permanent out-of-home care and experienced the same horrific abuse, if not worse. Thousands of voluntary placement like myself were placed in long-term informal foster care, never went back to live with their parents, therefore refusing to recognise our status as care leavers is against the government's own policy. The Australian government's complacently let us down abysmally as children. Despite having full knowledge that the children had been voluntarily placed in care, they breached their legal obligation to keep the children safe by following up on their welfare and whereabouts, which resulted in them becoming lost and forgotten inside a broken system. The horrific crimes against us have gone unpunished, and neither the government nor the authorities nor the out-of-home carers who brutalised us have ever had consequences for their negligence. We were not only humiliated and demoralised by being completely disregarded at both historical apologies. To make matters worse, we were also excluded from the National Memorial for Victims and Survivors of Sexual Abuse. Instead, all focus was on institutional abuse yet again. When will we get an apology for all the pain and heartache we've endured? When will we have a memorial erected in honour for all the placement survivors, past and present? When we talk about flaws within the government system, nobody needs to look much further than the abysmal treatment I've received and how my entire life has been a miscarriage of justice because of an inept and desensitised government officials. When I was 2 weeks old, I was formally placed in abusive foster care where I was shunted back and forth between foster care homes until I was a teenager. I moved so many times I eventually became lost, as there was no documentation pertaining to my care. Adversity is something that everyone faces at some point in their life, but sadly, I've been unluckier than most. I've spent my entire life bearing the burden of other people's wrongdoings. As a child, I made many attempts to inform my teachers, doctors, and other family members about the abuse that I was being subjected to, but none of them ever offered me any kind of support. When I was 13, the strain became too much for me. I suffered a mental breakdown. Despite the fact the teachers witnessed my meltdown, not one person came to my rescue, so I ran away to save myself. My friend's mother alerted the police to my whereabouts, and my freedom was short-lived. When I arrived at the police station, the senior sergeant in charge told me he would call my foster carer to come and pick me up. I broke down in tears and begged him not to send me back, but he wouldn't listen, which is something that they'd done in those days, sadly. Desperate not to be sent back to my abusers, I disclosed my abuse in full graphic detail, sparing no details. And even though it was sickening, he didn't believe me. I was a broken 13-year-old girl, sobbing and shaking, telling someone I thought would assist about the horrible abuse I was receiving, only to be ignored. I was told that if I ran away again, I'd be sent to Win Leighton Girls Training Centre. Then I was cruelly taken back to my abusers. That would be my first experience being let down by the police, but it certainly wasn't my last. Like many other survivors, the Cardinal case forced me to confront a dark side of my life that I had been repressing for a long time. It made me reflect on the many injustices I had experienced at the hands of everyone I should be able to trust. I grew up being told I was a state ward, so I applied to the Freedom of Information Act, a Freedom of Information to release all my childhood records, and that's where it all went wrong. They could not find any record of me. I came back with nil documents. The only thing they could suggest is I was a voluntary placement survivor, which I'd never heard of, and from what I'm gathering, very few people have. They suggested I try Open Place to look for my records, of which I did. They sent me a welcome pack. 2 years later, I wrote back and said, I still haven't heard from you. Oh, sorry about that. you don't qualify because you have no documents pertaining to your record. As if I wasn't feeling demoralised enough, I applied to freedom of information, was unable to locate any records of my childhood. Open Place turned me down due to absence of documentation. I made an appointment after hearing about the National Redress and had a lengthy interview to see if I qualified. What a choke that was. I told them that I was not a ward of the state and that I had no childhood records proving my time in care. To my dismay, they sent a copy of the conversation and, unbelievably, nearly every detail was wrong. I called the National Redress and expressed my dissatisfaction at the interviewer's poor listening skills and how they'd clearly mixed my file up with someone else's because there was just too many mistakes. I received a revised copy of our conversation as well as a list of the law firms that handled historical abuse cases. As they sent this list and they didn't say otherwise, I assumed I was eligible for the National Redress. So I spoke with a solicitor from a major law firm, sent all the necessary paperwork and was informed that I had an extremely powerful case. As time passed, I still had not received a reply from the solicitor. Tired of waiting, I phoned them, only to be told very bluntly, "We acknowledge your terrible childhood rape and torture, but as you are not a state ward and have no paperwork pertaining to your out-of-home care, there is nothing in it for us." Yep, he actually said those words. There's nothing in it for us. What a thing to say to someone. Feeling despondent, I tried yet another major, one of the biggest law firms in Victoria. We take cases unless the offender has assets. That's why we focus on institutional abuse cases. That is what I was told. I was rejected again. Sadly, institutional abuse cases have become a licence for money for solicitors. They don't want to know about anybody else. I submitted so much evidence. I didn't care. The first question was, does your perpetrator have assets? No. Do I have assets? No. Goodbye. They say that the foundation of justice is made up of the following: fairness, involvement, and accessibility. In an ideal society, everyone feels respected, provided, and protected. That may have been the case in the past, but not today. Access to justice is determined by how much money the law firm stands to make. There is no justice for the poor, unless you, of course, your perpetrator's got assets. I informed the National Redress over the phone that I had been turned down by the law firms. They promised me everything would be all right and scheduled another appointment for me to call. I spoke with someone again a week later, this time sharing my disappointment with the decision and what the solicitors had told me. I was met with a very cold and callous reaction from the representative who informed me that if I don't qualify, I was not a ward of the state. So that's it. Case closed. Why? After all the information I gave the National Redress, why would they proceed with the entire case? Why did they give me the illusion that I was qualified? Only to let me down. If that injustice is not bad enough, I then went to socket. I could feel my mental health deteriorating after a string of setbacks, including the unsuccessful Freedom of Information search, Open Place, and two major law firms refusing me. In an effort to obtain justice for all the injustices I had experienced throughout my life, I went to the police station and spoke to the sexual abuse investigation team, socket. But to cut a long story short, that was an absolute abysmal disaster. 18 months of opening Pandora's boxes, picking at wounds until they bled, supplying a multitude of witness statements. COVID hit. Police got transferred to other stations. Interest went downhill rapidly, and inexplicably, it went from we're going to get this bastard to, oh, suddenly my perpetrator had developed dementia overnight, even though he'd been interviewed by 2 experienced, seasoned sergeants. My miserable socket experience left me feeling as powerless and psychologically violated as I'd been felt after multiple rapes. Over the course of 18 months, I'd gone through every agonising detail of the horrifying torture and trauma that I had buried for decades. I engaged a lawyer. With her assistance, I applied for VOCAT and they wrote back, and oh my God, I swear to God, I couldn't believe it. If I was a fish, I would have drowned. They wrote back that though they had acknowledged the violent act against me under Section 77 of the Victims of Crimes Assistance Act, which outlines the transitional provisions for historic offences. In other words, he hadn't been charged, so yet again, I won't be getting any justice. Why does it matter? I'm often asked why I continue to push for survivors of voluntary placement to be recognised as care leavers when it's clear that no one cared then or cares now. I can only respond because I care as thousands of other voluntary placement survivors who are the invisible generation, those who were abandoned by their parents, shunted between unofficial sadistic foster parents, then lost and forgotten because there was no paperwork to support our time in care. Think back to when you were a child and all the happy memories you have. I don't have these memories. All I have is nightmares. We are not a minority. It should not matter if the abuser was a family member or a member of an institution. The fact remains that the Australian government was derelict in its duty of care to protect us as children and left us to the mercy of perverted carers. As voluntary placement survivors are sadly passing away with everyone without ever having their neglect in care acknowledged, for this reason, I'll continue fighting for the justice until my voice is finally heard and our identity as care leavers is recognised. Sorry, I've got a cold. I will keep advocating on behalf of voluntary placement survivors in spite of the lack of interest in my cause, hoping that one day a government official will take a stance and say this is wrong on so many levels. Voluntary placement survivors deserve better. And that's about it in a nutshell. I'm just looking for justice, nothing more, nothing less.
Thanks, Tracy. That's a very powerful statement that you've made to us. Can you just tell me about this e-petition? Where was that to? The state government, was it? Victorian state government?
Yeah, the Victorian government, the legislation, yes. Yeah. Michael O'Brien sponsored that.
And can you just tell us about it quickly?
Well, I've virtually put in it what I've just given to you, except I've also sent a submission to the National Redress. That one was a lot more detailed with a lot more sites in it. The petition purely stipulates what I've just said. We haven't been shown justice. We are discriminated against. All focus is on institutional abuse. And we all know why, because you can get money out of the Catholic churches. You can't get money out of families. It shouldn't, as I said, it shouldn't matter. We were still abused and forgotten in care.
Absolutely, yeah. You talked about a lengthy interview and what a joke that was with redress. Yes. Can you talk us through your concerns there?
Well, because I did read the criteria for national redress, I am very well read. So I always make sure I have my facts straight first. So I actually looked at the guidelines for national redress, and it clearly says you do not qualify under these rules. So I knew I didn't qualify. But then there was a few contradictions in it, and I thought, well, I'll just give them a ring and run it by them. So I was very open, very honest. I clearly told them that I was not a ward of the state, that I had been put in voluntary placement, lived there my entire life, but didn't have any paperwork pertaining to my time in care. Now, 2-hour interview this was. It wasn't a brief interview. I was asked every question pertaining to my childhood you could possibly be asked. Nobody misunderstood that I was not a ward of the state. I couldn't have made it clearer.
Yeah.
Okay. Somehow or other, when the transcript came back, I mean, if it wasn't bad enough, they got my birthday wrong. They even got my name wrong. They got my address wrong. They got my age of going into care wrong. They got the age I left. There wasn't anything they didn't. It was clear that they had obviously made some keynotes because it was a telephone interview. And I think at the end of the day, they've just sat down and they've just drafted up each person's file, confusing my details because it was, I'm 62, the person that,
yeah,
it was too, blind Freddie could have seen that somebody had made a tremendous error. And I didn't make a big deal about it. I just contacted them again and I said, well, it's either one of two things. Either somebody wasn't paying attention when I was talking, or you've confused my file with somebody else's. I would say it wasn't paying attention, because the problem when you talk on a phone, as you will know, it breaks up, you get an echoing, it's never clear. So they probably filled in the gaps with as much as they probably thought they could hear. Well, the whole experience was re-traumatising, I can tell you that, because I honestly thought I had been accepted. And when I rang them back at the end and told them that I had been rejected by the law firms because I wasn't a state, she virtually put it back on me as if, well, why did you waste my time? I couldn't believe it. I said, I don't know why you're being so facetious. I said, because it was actually you or someone in your department that sent me the information after I clearly told you I was not a ward of the state and that I had no paperwork. I said, and if you go back and look at that transcription, you will actually see that it says it. So people make mistakes, I'm very aware of that, but fundamental mistakes like that are inexcusable. It's bad enough you already have to go sit there for 2 hours and pick at parts of your life you just don't want to remember. You're trusting them with that information, and then at the end of it, you're let down because of their complacency. They've heard it so much, it's like, oh yeah, here she goes again. You can feel it. You can actually feel the complacency over the phone. And it's very hard not to become desensitised when you hear the same stories over and over again. It becomes a business, and institutional abuse is one very, very big business. And once you say you weren't institutionalised, it's like your abuse doesn't matter and you are literally just thrown in the bin.
What?
And
sorry.
Go on.
We're running out of time and I haven't even let anybody else ask any questions yet. But if people are happy, if we can ask the next witness if he minds if we take an extra 10 minutes with this witness. Andrew, is that possible? Because then we're going into lunch, so if that's possible.
We've still got another 12 minutes, Chair, so I think why don't we see how far we get in the next 12 minutes?
Yeah, I've got quite a few questions. So you talk about no records, and yet someone must have known where you were.
They knew. This is the contradiction. When I was 18 months old, my mother went to the Supreme Court in Victoria, Broadmeadows Court, and went through. Back in those days, they used to do the divorce hearings and the custody hearings on the same day. So she walked out of one room, divorced my father, walked into another room to do the custody hearing. She was granted custody of the children, walked out of the courtroom, and handed her kids over to, she didn't want them, she just didn't want my father to have them. But on the custody record, and I've got a copy, it says Tracy is in temporary care with one of my family members.
Yeah.
Now, and it also says I was to be taken back as soon as my mother established herself. Well, she never took me back. Nobody checked up on my welfare or my whereabouts, and I just got shunted from family to family. And no one, the freedom of information, I've got to give her credit, she was wonderful. She spent months trying to find records of my care. Now, I've got a feeling my family must have been a bit dodgy because there wasn't anything in writing. And I said, but that's impossible because I went to schools, I was in hospital. They found a couple of hospital records when I was a baby because I nearly died a couple of times. But other than that, there was nothing until after I was 18. It's like I just fell off the earth. And
No
I said, I
school
don't
records?
understand. Beg your pardon?
No school records?
I've applied to all my schools that I went to. I said, I don't understand why you've got no records. Here I am in a photo at your school. I said, it's that word. It's complacency. Everything is complacency. Everything's an effort.
Yeah.
I have school photos. I have doctors. I have visual things, but there seems to be nothing written. And I don't understand that. Now, the biggest contradiction is they've got no information pertaining to my time in care, yet one of my carers was getting child endowment.
Mm.
Now,
Yeah.
does that not sound a bit odd?
It's a bit
But
crazy.
here comes the next wonderful government thing. They decided to destroy the endowment records.
The state government?
Yes. What can I say?
Yeah.
That's why I said they should have hired monks, because at least monks knew how to keep records.
Okay, I'm going to give other people a chance, and if I've got more questions, I'll come back to you if that's okay. Who wants to go next? Senator Shoebridge, Mr. Zapier?
I've got just two questions. Ms. Ullman, thank you for giving us that powerful opening address. When you moved from foster parents to foster parents to foster parents, do you know who identified the foster parents you were going to move to? Was it referenced back to your family?
It was all within different families.
Was it just, as far as you understood it, was it the families themselves just sort of passing you from family to family?
Yes.
And there was
You were just handballed. What it was my father was in the Merchant Navy, and he used to send across, back in those days you had to wire money across.
Yeah.
I don't know if you're as old as me. But once the money ran out, they lost interest in me. So they'd handball me to the next family. And it was just a verbal thing.
Yeah, so it was a very informal thing. It didn't bounce off to the State Department. You didn't get no one got a foster parents allowance. It was just your dad would occasionally wire some money in.
Well, no, because they received child endowment, which means the government knew I was being cared for because they had my carer down as my guardian. So if that's not a contradiction of terms, I don't know what is.
So
how can you...
Yeah, there was some...
Obviously knew.
There was some official recognition that you were with that parent, with that family.
Well, one would think so, but they're saying there wasn't.
And they're the documents you've been trying to chase and got nowhere, is that right?
I've been trying to chase anything to prove that So the problem is with all the organisations, including National Redress, the lawyers, they want evidence that you lived with X person. Unfortunately, I don't have anything to say, well, I lived with Joe Blow in 1975. As far as they're concerned, I lived with my mother my whole life, and because I've got nothing saying otherwise, which is wrong, because as I just said, they have my auntie called herself my guardian.
Also, Tracy, you have your own memory of your childhood, and you know that was wrong, and I fully accept that. Have you considered putting in a victims of crime application? Has anyone taken you through the possibility of a victims of crime application?
No, because where's the paperwork? VOCAT knocked me on the head. Socket knocked me on the head. National Redress knocked me on the head. So I can't see victims of crime is going to be any better, because everything has to have evidence.
Have you
and
gone?
That's what I'm lacking.
You're in Victoria, aren't you, Tracy? And this happened in Victoria.
I am, yes.
Have you gone to a community legal centre and asked about victims of crime?
No. When two of the major law firms that specialise in historical abuse told me that I don't have a case and no lawyer will take me, I just gave up.
Yeah, I can't guarantee you'd get a better result through victims of crime, but sometimes victims of crime statutory schemes operate differently to how the redress scheme or civil litigation can operate. And I can't guarantee. I can't guarantee that.
I think you've missed my point. Why I'm here? I'm here because I'm a voluntary placement survivor that suffered horrific abuse in care. The government knew I was in care. I was left to rot in care. Yet I am not considered a care leaver, and I want to know why. Why was our abuse any less severe than institutional abuse? Why do they get all the focus and we're constantly overlooked? That is my question. And that's one that nobody seems to want to broach. And we all know the reason. It's because if it's institutional abuse, then the government can hit the organisations where they're in care. They can make them pay for it. But when it's a family, unless we've got multimillionaires in our family, we just have to suffer quietly. Nobody wants to say, well, hello, we were wrong. We should have protected you. Instead, you just fob me off to the next MP, hope I'll go away, and do the cut and paste generic comments. And, well, I'm not going away because we do qualify as care leavers as stated in your Social Services Act. We did live in care under 18 permanently. So why is that any different? Why are people finding it so hard to grasp that concept?
Well, Tracy, this is the scheme is about institutional abuse, and you are correct in noting that there's a whole lot of arbitrary and unfair boundaries on that. People who are abused in a family setting, people who are abused in informal care arrangements like you make out. And I accept 100% what you say, that those boundaries are unfair and arbitrary and mean people like you do not have access to justice.
All I want before I leave this mortal coil is to get justice. It's not about money. It's about someone sitting up and saying, we were wrong. What happened to you should never have happened. We should have intervened. We were negligent. I sat there at 2 apologies and listened to people apologise to institutional abuse for the unfair neglect they experienced, while we sat there invisible. Like, you might as well leave because this has got nothing to do with you. You're not part of the elite group. What do you think that done for our psyche? And still does. It is demoralising to think that our abuse is so insignificant in the government's eyes. I do qualify for National Redress. I do qualify to have justice. But for some reason, the government's own discrimination against voluntary placement is nothing short of disgusting. You're constantly re-traumatising survivors by telling us we don't matter.
Chair, they were the questions I had.
Thanks, Senator Shoebridge. Mr Zapier?
Thank you, Chair. Tracy, thanks for appearing before the committee and outlining the details that you have. You do matter. That's the whole thing. You do matter, and so does everyone else who experienced a similar circumstance or situation as yourself. It's how we find a way of ensuring that you get properly recognised, and that's a dilemma that we have to pass across as well. But can I ask you this? Do you have any personal recollection of the names of the families that you were with at different times?
Of course I do.
Yep. And
unfortunately, they were family.
No, I realise that, but would you be able to provide a list of those names to the committee?
Absolutely.
To the best of your ability. One of the things you said was that in one case the child endowment was stopped and the person got angry with you because of that. It seems to me that the records, and I could be wrong, but it seems to me that the records would have been kept by the state jurisdiction, but yet the federal payments would have come from the federal government. That is child endowment. And so therefore, and so there's effectively two departments here, neither of which are forthcoming with records. And I think that that's a matter that we should pursue.
The thing is, I'm not Robinson Crusoe. Do you know how many thousands of people? I'm actually on I run a page on Facebook for people similar to me. The amount of people, which I find tragic, in their 60s, 70s, when I've actually started to do this, I've explained over and over again what voluntary placement is, and they've turned around and go, oh my God, I didn't even know that was me. I used to get shunted from one family to another. I didn't know it was a name. It's been so played down, we don't even have a name. I tried to do this petition. The amount of MPs I had to send a description from Find and Connect to explain to them what voluntary placement were. They said, I lived in Australia my whole life, I've never heard of a voluntary placement. That's what we're up against.
Yeah.
And that's not their fault.
Yeah.
That's the government's fault, because they have subdued us for so long and tried to make us just go away that they've done a good job, because we are invisible.
No,
Yes, I do have the family names for what it's worth.
Well, I'm not sure that we can do anything with them, but there's no harm in trying.
At the end of the day, I've got a perpetrator that is still walking around bold as brass, that has abused multiple people in my family, and I cannot get justice against this person. Why? Because I've got no paperwork. I mean, how utterly ridiculous when you've got VOCAT that clearly says we recognise your torture and rape, but how can there be a but? A child was raped, end of. A child was tortured, end of. It shouldn't be a but. Yeah. It shouldn't matter if it was a priest or a cousin. The outcome was the same. It was an horrific violation of a child's innocence. There's no buts.
Well, Tracy, you've raised an important issue with this committee. How we deal with it, we're going to have to think through what options are available to us.
Well, all I'm asking, and I don't think it's a big ask, is not to turn the screen off and then just throw that in the bin and put it in the too hard basket, which many, many, many MPs and senators have done in the past.
Yep.
I just ask you to reflect on it, to actually listen, and it'd be really nice if everyone got together and done something, because I don't think I'm asking a lot. I'm not asking any more than an institutional abuse child, or survivor, I should say.
No, thanks for that. We hear that. We hear that very clearly.
We do. We do hear it very clear. We will be doing a report, and that will have some recommendations to government. I can't preempt what those recommendations might be, Tracy, but can I say I'd be very surprised if there wasn't something about voluntary placement survivors. So I don't want to build up your hopes, but I want you to know you have been heard today. That's exactly what this committee is about. You have been heard. We thank you very, very much for your submissions and for appearing today. Your evidence has been very forthcoming. And I think, well, I know you were asked to provide some additional information. Can you please forward that to the Secretariat by Thursday, the 15th of August, 2024? You will be sent a transcript of your evidence and you will have an opportunity to request corrections to that transcription errors. I'm sure it'll be better than what came from the department in the transcript. With that, can I thank you for your time today, and we'll move on to the next witness.
Well, thank you very much for giving me the opportunity to listen anyway. Thank you.
You're very welcome. Thank you.
Bye-bye.
Bye. Okay. I welcome Robbie Gambley to give evidence today for the committee's inquiry into the operation of the National Redress Scheme. For the Hansard record, would you please state your name and the capacity in which you appear before the committee?
Hello, Senators. Yes, my name's Robbie Daniel Neil Gambley, and I have an application with the National Redress Scheme.
Great. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I ask all witnesses to respect privacy and to refrain from naming or identifying individuals as being victims or survivors. The committee can hear evidence in private session if necessary. Mr. Gambley, I now invite you to make a short opening statement. If you can limit it to 5 minutes, that gives us more question time. If you need to go over 5 minutes, we understand. And then after that, we'll proceed to discussion.
Okay, thank you very much. I'm not sure if you can see me. I can't see myself on the screen, but
No, I can see you.
okay. Well, I apologise for my tyre. I'm in casino and I live on a disability support pension. I'm an asthmatic. I have sinus. I've got to have a sinus operation. So,
It looks a bit cold there. Is it cold there?
Well, my unit faces the south, Senator, and yes, it does get cold. So, so if I sound a bit
I'm in
nasal,
Tasmania, so I don't know if you can see me, Mr. Gambley, but I'm not dressed in a suit, let me tell you.
I can see you. Well, Senators, and I would just like to thank you and all the staff for working on a subject that's one of the most evil and insidious crimes on this planet. And thank you for caring. And we want the abuse to be stopped. And can I quickly add that I lived in Canberra for 4 years. I worked in a racing stable as a Yas. The boss was cruel to the horses. We had a blue and I left and I went to Canberra. I worked for the Parliament House Construction Authority that built the new Parliament House, and I have a certificate. I'm not sure if you can see the certificate.
Yeah, hold it up a bit in front of your face. Yep, brilliant.
So I just wanted to show you that. I worked for the office was in Manuka, and we were in charge of the building of what I call the new Parliament House, and that certificate is signed by Mr. A.L. Morikoff and the Honourable Bob Hawke. I'm proud of that. So, yes.
Good job. Well, it's still standing, so you must have done something right.
Yes, it was a wonderful job. May I outline the two sections that upset me with the National Redress Scheme is the institution section and the indexing. When I put my application in, I was told when I was offered a payment, on my I asked for an explanation of it, so I have it in writing, and it has institution section not applicable, and that is extremely hurtful because how can the abuse be any different in one institution to any other institution? It's it's that it can't be viewed differently. So that's one point. And I would like to make the other point on the indexing. The indexing was brought in, and I gave evidence to the most wonderful Justice Peter McLennan. What a beautiful man in Sydney. They flew me to Sydney for that. That was very difficult. The Royal Commissioners, as you know, recommended a maximum of $200,000. And we all know that was lowered to 150, but the original indexing amount was kept, which I think it's grossly unfair. If you lower one, surely you've got to lower the other. And the two things are, I ask that the institution section should be just abolished outright, and same as the indexing. Scotland, not many people know this, and I did give evidence. There was a meeting on the 6th of March 2021 when Ian Ruston was the minister. So that was at the QT Hotel, formerly the Lakeside, in Canberra. There was about 80 people there, and I put a lot of work into that. And I have a back injury. I'm due to have major surgery on my spine in September. So it was painful, but I did it. And I spoke and put the views forwards, and there were about 80 people there. I think there were 3 Aboriginal groups. But I was the only one that spoke about Scotland. Scotland has a redress scheme, and their redress amount is a gracious $186,000 AUD. So depending on currency fluctuations, that's what the amount is. And when I think Scotland's system is so much better, when a survivor, whom I call brave people, when a survivor, a brave person makes an application, they are given a person to support them, and that person stays with them the whole time. Then when their application goes before a panel, and so the whole panel members read the brave person's application, and a panel makes the decision, not an independent reviewer. And this independent system, one person reviewing a case, for me is incredibly scary. A person's fate rests in one person's hands, and I just cannot see how that works. To me, it doesn't work, because I was made an absolutely pathetic offer. I rejected that, and so I've made that point. Another point is, which is the emotion of it. I've been very public, senators. When I went to the police after my court case, the perpetrator pleaded guilty. I wanted to do a story in the local newspaper, the Northern Star, and also the ABC. So there's numerous stories in the ABC North Coast. When I got home from doing that story, a gentleman and his wife rang me from Grafton. And this man was in his 70s. He was very emotional. I don't take calls like that anymore. It's just too emotional. But he said, I told him about that he could appeal. I also told him about No More. My application is with No More. And I want to thank the No More people, and I want to thank the government for supporting No More and having No More to support survivors. And I will name the first name of my lawyer. Her first name is Emily, and she is the most wonderful, kind young lady. So I told this gentleman about the No More and that he could appeal. But his wife also did the talking. But the gentleman said to me, he said, they have offered me nothing for what that beep beep did to me. And as I said, it was very emotional, and I said, well, you can appeal and about no more. And the call ended. I got off the phone and I cried. It was very hard to hear that. And I just think, well, that's mighty Australia's the might of Australia. That is our redress scheme. That's the way it works. And and I've already said about Scotland's, how Scotland's appears to be so much better. And can I quickly add that that Scottish system, how they have panel members and go before a panel, having a support person is very similar to Victim Services New South Wales, because when I went to the police, they told me about Victim Services. And I applied for a Victim Services counsellor to have counselling, and Victim Services New South Wales, I'm sure that you people know, but you go to a team. So when I wanted to ring them up, I could just ring a 1-800 number or whatever it was, and I'd just say, it's Robbie Gambley, Team B. So they put me through, or Team A, and so they put me, Team A sounds better. So they put me through to Team A, and it was the same people. They're a team. So I spoke to the same people each time, which I thought that's a suggestion for the National Redress Scheme. That system, I felt comfortable with that. I thought that worked very well. And I have contacted John Riley, who you would know works with the National Redress Scheme, and John's a very kind man. So, yeah, they're about my points. Thank you very much, Senator and Senators.
Thank you very much. Couple of things. Have you got any more? I mean, I can Google this, I'm sure, but have you got any more information on the Scotland redress scheme that you think would be of benefit to the committee? The panel idea, I think, is a very good idea, personally.
Well, thank you. Yes, Thank you for that. Well, I don't have a site. I forget how I just Googled. I forget
yeah, and we can do that.
Thank you.
Yeah, I'll do that after. But it's really interesting to hear about how other people are doing it.
Yes.
And the benefit. You mentioned that you received a pathetic offer.
Yes.
Did you appeal that?
Well, it's in the process.
It's still in the process.
I'm one of those people. I'm just hoping and praying that, that Australian people will have the compassion to make just changes, so people can get some justice. I heard the lady speak before about justice. When for the Royal Commissioners to recommend at 200,000 and for it to be dropped to 150, and then still keep the indexing, and it's just very upsetting. And as I said, the institution section, that robs people of a certain amount. And I survive on a disability support pension. Due to the abuse, my social worker called it ultra machoism, and that I didn't do as well as I did my HSC, but I didn't do as well as I had planned. I did work in the ANZ Bank. I worked, and my father had cattle properties at Albanalbo and Bottle Creek. We grew up in that area. So I moved out west, and I worked west of Moree. The property was near a little village called Weemila, which is near Mungandai. Mungandai is on the Queensland border, New South Wales-Queensland border. So I was 20 when I hurt my back, so I've lived with back pain all my life. And I don't have great computer skills.
How did you find the redress scheme overall, like your experience with the department and all?
Thank you. Is your name Bill? Is that the correct?
Billick. Yeah, Billick.
Billick. I apologise. Thank you, Senator Billick.
No, that's fine. That's fine. I get called all sorts of things.
I actually looked you up, and when Nathan told me about that I could give evidence, and once again, I thank all the senators for doing this very difficult work. I can appreciate it's very difficult. Honestly, which is what I'm here for, I have found the National Redress Scheme to be incredibly cruel, incredibly triggering and upsetting. When I was made the offer, there was no support. They just rang me up. The National Redress people rang me up and said, "Oh, Mr. Gambley, it's so-and-so here to give you your offer." Like I was supposed to have a support person from No More, and I in the shock of it, I just said, "Oh," she said, "Do you want to hear what the offer?" And I said, "Oh, yes, go ahead." Well, 5 minutes later, I was crying and in tears. And I know this is past history, senators, but I put so much work into my application. I had a photo, I had, which was a copy. I had a police statement. I had documents that were in pristine condition. When I rang No More, they said, "ARCS, tell the redress people that you wish for your case to be withdrawn and that you'll go with No More." When I did that, there was silence, and I said, "So what do I do now? My documents are sent back to me," and the person very bluntly said, "Oh, well, your documents have been destroyed, and they've been put on digital form and been destroyed." And I mean, that was within probably a week to 2 weeks. So they just destroyed my documents. They didn't even ring up and say, "Would you like the documents back?" There was nothing. So that alone was incredibly distressing and upsetting. And then, but the worst thing was when my No More lawyer got the documents, whoever photocopied them, instead of it going page, I know they were double-sided, 1, 2, 3, 4, it went 1, 2, 3, 7. It was all out of order, and it was a very dodgy photocopier because it was very hard to read. And I apologised to the people. I said, "Look, I'm sorry for that." So that was a total inadequacy there, the way that was handled. I know that's past history, that's gone and done, but
it's good for us to hear it though, Mr. Gambley, so that we can, you're not alone in some of these things you're telling us, and it's our job to, try and make the department work as well as they can. And some of the things we've heard, frankly, we've been appalled at. So
yes, thank you.
Even though it is past history, it's good for us to know that. So they just rang you up. Did they send you anything in writing?
I asked for the explanatory letter.
Yep.
And that's when I found out that it was listed, the abuse, it's different categories, and it had institution section not applicable. That fired me up.
Yep.
So that's why I've held on, and that's why I campaigned for that. As I've said, I don't see how the abuse in one institution is any different to any other.
Yeah. I might come back with a couple of questions if we've got time, but I'm going to throw to Mr. Zapier. Have you got questions?
Chair, thank you. Robbie, you've actually answered some of my questions in the last part of your presentation just now. But I understand that, or from what you've told us, that they had made an offer to you, albeit that they only gave it to you by telephone, which in itself I find disappointing.
Thank you.
But that implies that they accept that you do have a case for redress. But I understand also that the amount that they've offered is very little, which I find there's a contradiction just in that alone. In other words, you're entitled to something, but look, it's only a small amount whatever the case is. Did they ever tell you how they came about to come to the offer that they made? What was the criteria that they said justified the offer that they made, or did they not tell you that?
Thank you very much, Senator. I'm a bit emotional now. That's when I applied for. I said, "Can you tell me what were the criteria that how the process went through?" So that's when I received the letter of the payment and the deductions that were and everything like that. And I did, yes, it was upsetting.
Yeah.
So I have that letter, Senator. I still have that letter with the, which of course my No More lawyer also has.
And you said that your documents were destroyed and supposedly they've been digitised. But again, they never offered to return them to you, and I think that's what you said earlier on.
Yes.
Okay. And do you know if that's the case for anyone else? Do other people have their documents destroyed? I mean, we can ask the department that, but I'm just curious whether you've come across anyone else.
Thank you very much for caring, Senator. I think I was told it's standard practice, and I appreciate that. I put my application in once the National Redress Scheme was announced. So this was back in 2018, and excuse me, the gentleman, he was very blunt about the whole thing, which again, I think it's worth saying that that in itself was very upsetting. When I saw what they sent me back, the mishmash that they sent me back, there was another big cry session. So it's just traumatising, it's trauma that you don't need to go through, like I drank, I took other substances, and the medical term, I'm sure you people know, it's called locking. And down in Canberra, I had motorbikes. That was probably the most dangerous time in my life at that time. I didn't care whether I lived or died, but I don't drink now. I don't use any substances, and I eat and drink very healthily. But to answer your question, to me that seemed to be very just the standard process. I wouldn't have minded had they have sent me. Well, I would have appreciated I put so much work into it. And to give you some idea, my documents that I sent to the National Redress Scheme, I appreciate that my police statement, which was quite lengthy, they were in envelopes. But still and all, that's just a A4 envelope.
Yep.
If you sat when I sat my documents on a table or a desk, they were over 2 centimetres thick. They were close to an inch in old language. So I put so much work into it, thinking I'm going to get justice. This is a fair deal. Oh, sorry, I'm a bit emotional. That was very upsetting. But I moved on.
So my question really is this: do you know if all of your documents have been digitised? Have you ever viewed the digitised version of them?
Yes, I as I said, I got when they photocopied them.
Yep.
I got that. It was of very poor quality. And as I said, for some reason, I just do not understand why, because I've got a copy of it. Yeah. They were out of order. Like it would go 1, 2, 3.
At least we know they're all there.
Yeah. Yes.
Yeah. Okay. I think David might have a question.
Yeah, and just before we go to Senator Shoebridge, I just want to ask you this: you say that when you got the documentation about your first offer, that the institutional section was marked NA. Do you know why that was? Was it that no institution was found responsible, or had the institution not signed on, or do you know why that was marked like that?
It said I didn't qualify, but the thing was, senators, it was a public school in the state of New South Wales. So
and a science teacher too.
Yeah.
Yes.
Is that right?
I'm just wondering why they say it. Yeah. Okay, sorry, Senator Shoebridge.
Yeah, Ms. Gamble, have you spoken to know more about challenging that? Is that part of what's grinding its way through at the moment?
Yes, thank you, Senator Shoebridge. Yes. Once things settle down and I'm waiting to see what you people do, yes, I will appeal that.
Yeah, and you probably know there's kind of timeframes for that, and you're talking with no more about that and making sure you've got things are on track there. You're talking with no more about that?
Yes, I have. I actually sent an email to Mr. John Riley, who's been very kind, and so I applied for an extension on my application.
But I've got to say, from my perspective, if the abuse happened at a public school and it was perpetrated by a teacher at the public school, it's hard to explain how they say it wasn't institutional abuse. And I'm glad you're challenging that, Mr. Gamble, and making the case.
Oh, thank you. Thank you very much, Senator. Thank you.
Yeah.
Appreciate that.
And also the destruction of your documents without telling you. You're not the first survivor who's told us about what an emotional process it is to document your life, to put it in writing, and also to gather the associated documents. And I just want to tell you, I think it's disrespectful in the extreme to just destroy your documents without telling you.
Yes, thank you very much.
And
a law firm would, as you would understand, a lot of law firms save documents for 7 years or longer. So that was the shock. I just couldn't understand. So why would they be destroyed so quickly? Anyway, that's done. You know,
well, it might be done, but we will definitely ask redress about how on earth that happens without talking to people, without giving them the right to have it returned. Because
thank you very much.
It was your application, and then were there any original documents? You know, documents from your history that you included in that?
No, thank you. Everything was copies, but I included a photo of me when I was 10, just to try and get the message of me when I was 10 on my father's cattle property with a bay mare, Brownie, and to have that destroyed was very upsetting. And I think there's an apt time. May I just interrupt and just say, please remember that we were innocent, beautiful, happy, wonderful children when the abuse took place. I mean, I say, don't look at me the way I am now. Please remember that we were children. We were innocent, vulnerable children.
Mr. Gamble, I've got in front of me a copy of that photo of you with the horse.
Oh my goodness!
Yeah, we've all got it, Mr. Gamble.
And you were, you were everything you say about you were as a kid, but you're important now too.
Thank you, sir. Thank you. Thank you.
So yeah, I think we'll ask. We have a lot of questions to put to redress about this, and so thank you for raising it with us. And as I said, make sure you get that full and frank advice about your appeal rights and pursue that vigorously as well.
Yes.
All right. Thanks, Mr. Gamble.
Thank you.
Thank you.
Thank you so much, Mr. Gamble, both for your submission, and that photo is in there, as well as another one of you at a car door.
Oh, I see. That's
from the ABC article.
Yeah, that's from the ABC.
Yeah, that's right.
Can I quickly just add that I always say that this subject is above politics. It's such an insidious evil crime. I probably wrote over 30 letters to politicians. I started that in 2016, what I was calling the healing ceremony, which turned into the national apology. It was the wonderful Tanya Plebisek who invited me, who rang me and invited me down to Canberra for the national apology. And Tanya has that photo of Robbie and Brownie. I just say it's Robbie and Brownie. So yeah,
That's lovely.
And we didn't have a camera for 10. The meaning of that photo is we didn't have a camera at the time. It was only a Boy Scout on a stay. He loved Brownie. He came from Brisbane, and he said, "I'll get a photo of you." And so otherwise, it never would have been.
Oh, that's such a nice story.
Yes.
Mr. Gambley, we're out of time.
Right.
But I really do want to thank you, as I said, for your submission and for appearing today. Really, really nice to be able to talk to you and hear not only your concerns, but your suggestions for things that might be able to change. If you've been asked to provide any additional information, can you please forward to the Secretariat by Thursday the 15th of August 2024? You will be sent a transcript of today's evidence, and you will have an opportunity to request any corrections to those transcription errors if there's any. And now the committee will suspend for lunch and will resume at 2 p.m. representatives from No More to give evidence today for the committee inquiry into the operation of the National Redress Scheme. For the Hansard record, could you each please state your name and the capacity in which you appear before the committee? Who wants to start?
I'll start on Amanda. Sorry, we're good?
Sorry.
Yep. My name's Amanda Whelan.
Okay. We'll start with Jackie.
All right, great.
Yeah. Okay.
I'm Jackie Mead. I'm Jackie Mead, and I'm the CEO of No More.
Thanks, Jackie. Next.
Perhaps I'll go next. I'm Rachel Neal. I'm the acting principal lawyer at No More.
Beautiful. Thank you, Rachel.
And I'm Gary Oliver. I'm the Director of Strategy and First Nations at No More.
Thank you. Amanda?
Yeah, hi, I'm Amanda Whelan. I'm the Director of Client Services at No More.
Beautiful, thank you. And last but not least?
I'm Sean Bowes. I'm a Law Reform and Advocacy Officer at No More.
Great, thank you. This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I ask all witnesses to respect privacy and to refrain from naming or identifying individuals as being victims or survivors. The committee can hear evidence in private session if necessary. I now invite you to make a short opening statement of no more than 5 minutes before we proceed to discussion. Amanda, are you doing that?
I am, yes, thank you.
Thank you.
I'd like to start by acknowledging the Ngunnawal and Ngambri peoples, who are the traditional custodians of the lands that we're all meeting and gathering on here today, and pay respects to elders past, present and emerging. We acknowledge that wherever we are, we're on First Nations land and that sovereignty was never ceded over those lands. I also pay my respects to First Nations colleagues both here in the room and joining us online. My name's Amanda Whelan. I'm the Director of Client Services at No More. I'm speaking today on behalf of our CEO, Jackie Mead. Jackie is actually here in Canberra but became really unwell overnight. So she's joining us online but sends her apologies that she can't be here in person or well enough to give this introduction in full. So when I finish up, Jackie, if I've done a clunky job, please make sure that you jump in and pick up anything that I haven't properly addressed. So thank you. No more thanks, committee members, for the opportunity to speak today here about the scheme and the important issues that are facing our clients and our service. We commend the continued engagement and efforts of the committee and the department to support the ongoing improvement of the scheme, and we look forward to continuing to work with you in that aim. The NRS is an important way that survivors can achieve justice making through acknowledgement and recognition of the lifelong effects of child sexual abuse. The funded service system has been a critical way that as a group of services, we have helped to ensure that that process is also trauma-informed and culturally safe. In speaking with you today, and we note that we've also provided a submission, but there were some important messages that we wanted to convey. While there have been many significant reforms to the NRS since it started in July of 2018, the overall pace of that reform has been slow. And given the time-limited nature of the NRS, we are concerned that the clock continues to tick on many of those vital reforms. We also want to raise the issue of our funding, and we're seeking an enduring resolution to those issues that we've previously raised with the committee. We have really welcomed the additional funding for the 2024-25 financial year. We now, however, face a reduction in our NRS-related legal support services funding of almost $10.1 million or 25% in less than 12 months' time. Survivors in prison experience significant barriers, as we know, to addressing redress and support, and many of those will require additional resources for us to overcome that. The additional funding that was allocated to us for the 2024-25 financial year will enable us to assist survivors in prison in accordance with our current casework guidelines for the financial year, but not beyond. I want to just touch very briefly also on the current litigation or class action that people will be aware of. There's a limit to what we can speak about because it's a current legal matter, but we just wanted to, I guess, raise here that it is causing significant concern both within our organisation and across the sector. There's been media associated with those actions that's having a really serious and negative impact on survivors and their sense of justice and overall trust being achieved through the scheme and undermining the good intentions of what the NRS has been built to be. We have already been regularly fielding calls from survivors who are highly distressed by seeing these stories, and we are concerned that people are starting to feel like the fabric of their justice-making processes is being questioned or pulled apart. In closing, however, we also want to highlight that since we've commenced in 2013 with the Royal Commission and now into the redress work, as a service, we've assisted more than 25,000 survivors to understand their legal redress and compensation options. Our national footprint and outreach program means that we've reached some of the most remote parts of the country and ensuring that First Nations survivors have the same access to justice as all survivors should. Since 2018, 39% of who has come forward to us identify as First Nations people. We believe that that is a testament to our culturally safe, trauma-informed approach. We are incredibly proud of those achievements. We also know that there remains much more to do, and we look forward to continuing to work with the committee on those mutual aims. Jackie, any comments before I sign out?
Thank you for doing that, Amanda.
Thank you.
Thanks, Miss Whelan. And can I just say, I hope you're feeling better very soon, Jackie. It's horrible when you're ill and you're away from home too. So I'm
Thanks,
sure
Senator.
on behalf of the whole committee, thank you for even bothering to log in, because I might not have. So, yeah. Okay, who wants to kick off? Senator Shoebridge, must be your turn to kick off.
Yeah, thanks, Chair, and thanks for that submission. Can you just run me through what you thought you needed financially for this year in order to stop the backlog growing and to deal with the claims that are coming in, and what you actually got in terms of funding?
We got what we asked for, Jackie, that's correct. We asked for a sum of money to...
Senator Shoebridge, we believe that what we received for the basis of the scheme is correct, based on demand as it stands at the moment, except within the prisons work. What we asked for within the prisons work was, the lowest amount possible to begin to deliver advice into the prisons. If we were to deliver advice into the prisons at the same level that it's delivered to all other survivors, then we would need approximately another $3.5 million.
Yeah, and in fact, with the opening up, and it was a good decision to open up access to people who are in jail. There is a real risk, isn't there? If those claims don't start getting processed now, they'll end up becoming, well, effectively statute barred when the scheme ends. That's the real risk, isn't it?
That's the real risk, Senator. We know that through the department at the moment, there's a huge backlog of work with prisons, over 10,000 applications that have been on hold. They're fielding up to 200 phone calls per day at the moment from prisons as well. So that tells you the magnitude of the work. In Queensland during the Royal Commission days, no more had actually worked with over 4,000 prisoners. Now, that wasn't when there was compensation involved. That was when people were able to tell their story and bring forward what had happened to them, or survivors. We know there's the disappropriate amount of First Nations people that are incarcerated in this country as well. So ensuring that we have the opportunity to service that cohort of people is going to be very important, whether they're in the Northern Territory or Western Australia. We know the impact of them being incarcerated and the trauma that they've brought forward from their youth and when they were victims and what had happened to them as well.
And in fact, being able to properly service that particular cohort, people who have been institutionalised, who have a lack of trust, often who have, been severely traumatised, even though in some regards they're and I don't mean this as a lighthearted statement, a captive population, they it's actually hard work. It's hard casework, isn't it?
It's hard work.
Resource-intensive casework.
A vulnerable group of people that are looking for relationships to be formed to service their applications, and that's where No More offers as a difference the level of service that we do in our multidisciplinary teams. We have Aboriginal engagement workers that work direct with people to progress their applications, and some of those Aboriginal people are key people within the states in which they live and reside, and their family names are known as respected family names for those states. And those relationships are relationships that are formed beyond the terms of incarceration because the families connect with them as well.
Could I ask you about dealing with the different state and territory prison authorities? Well, I'll just leave it open to you. Tell me what's the state of play.
Yeah. So I think, generally speaking, we experience goodwill in that. Having said that, jurisdictionally everywhere does it differently, and then it depends on if it is a private or a public prison. So when we look at over 100 different corrections facilities across the country that all have people potentially that would be applicants to the scheme, everywhere has a different process for access, so they require different types of, ID verification. And I guess when you were saying about the resource intensiveness of it, the reality is for us it's even just the getting the access part that becomes resource intensive, let alone actually then doing the work. We have disciplines other than law who are subject to different requirements for getting access as well. So there's a lot to navigate, and as yet we're still trying to work through how we bring some sense making to reducing some of those really practical administrative barriers as well. Is
there a jurisdiction where it's working, where you've got a template that's working well?
We do know from the conversations that we've had with Western Australia that they've got a more mature model of servicing prisons and also the level of information to go into prison. But there are other administrative processes that as the NRS we need to consider for prisoners, and it's prison IDs. How do they ID people in prison? You wouldn't think they'd get that wrong. But also the bank account for prisoners as well, which our financial counsellors are actually working towards some of the difficulties in that space.
So in terms of finding the resources to go and have those conversations, as you say, not just even with one prison system in, say, my home state of New South Wales, but you talk to corrective services, then you talk to the private operator that's running one prison and another private operator that's running another prison. Are you just having to find those resources from within your general grant?
We did receive some additional resources for the current financial year, but as Jackie's outlined, it doesn't in any way meet that. So yes, the short answer is we do. We've always worked with people in prison. They've always found their way to us, but the volume has been steadily increasing over time. So whilst we've been able to sort of factor it into what we were doing, it's becoming a bit of a tsunami now. Like 80% of our most recent wave of allocations of legal work was for people in prison, and that's not what we're resourced to cover.
Has the federal department helped in any way? Have Redress said, actually, we'll do some of the heavy lifting for you, we'll make contact with the states and territories and try and open the door to the prisons?
We are working really closely with DSS, and I do need to, sort of say that we've had some really ongoing useful conversations. We've stood up a referral project with them, so that because they're in the yard phones across the prisons, and so we didn't want to duplicate that part of. Also, the other challenge and impact for people in prisons is the duplication of having to retell their stories. If you can only be on a yard phone for 10 minutes, they don't want to be spending half of that on hold trying to come through to us. So we've worked with DSS to do direct referring, but the reality is that they're facing a tsunami themselves. And, you know, certainly the access point, I think it's fair to say that we haven't had a lot of traction as yet in terms of, you know, landing some kind of coordinated effort.
All right.
Just as a confirmation, sorry, Senator Shoebridge, just as confirmation, following on from that question Senator Shoebridge asked, do individual prisons make the determination that you can go in, or do the state and territory governments?
Rachel, you might speak best to that.
Yeah, I believe it's actually the individual prisons, and it's dependent on the governor, I think, in some places, but yeah, it does vary. Generally speaking, as lawyers, we don't have an issue getting in to speak to prisoners, but there are some additional issues for our other disciplines, as Gary said before.
Yeah, thanks. Sorry, Senator Shoebridge.
No. And may I add as well, some of the complexity of it is that we are a national service, so at times we may have staff from Western Australia, from our Aboriginal engagement team, supporting an applicant from Queensland. And that provides a level of cultural safety because people don't want shame or family names connected to things. So then we have to have our Western Australian staff registered to provide advice or be on an a phone call to a Queensland prison. So you can imagine the complexity across all of the facilities and across every jurisdiction.
And, you know, we're well placed to navigate those complexities, but it does come back to the resourcing issue of where do we find the resource to do that.
Yeah.
And,
I'm sure we could spend longer talking about it, but I might just go to the class action.
Mm-hmm.
Could I ask first
just before we move off, Senator Shoebridge, can I just ask, have you come across any issues regarding claim farming in the prisons yet?
Absolutely.
Just while we're talking about prisons. You have?
We have,
Yes.
and we are. Senator, I've been addicted to TikTok over recent months.
I'm sorry.
It has been where these claim
Something I
farmers,
don't do. Sorry.
they advertise on it, and one claim farmer that has a name quite similar to a law firm from the Northern Territory has been travelling to South Australia and far north Queensland and providing survivor advice, they call it, but it's actually doing survivor advice, but providing referrals to a law firm. We are monitoring a law firm from Port Macquarie that has travelled to South Australia, and the Attorney General in South Australia has been working with us, and great. He's also the Minister for Aboriginal Affairs, Guy Amar, and introducing some claim farming law. So he's introducing a bill that there have been conversations with AGs across the country, because if we can get it to SCAG, it could be something that could be replicated. Now that offers a $50,000 fine for people found to be claim farming, not just for NRS but for any redress system, and it also offers some regulatory function for law societies as well.
We also remain really concerned around other vulnerabilities and risks that are very particular to people in prison, because whilst we absolutely welcome the expanded access that people in prison have to applying, we do remain concerned about not just claim farming, but how it is that people come to know and put pressure on individuals in the first place to sign up. As well as how we can protect people and their money in prison as well. And these are issues which, you know, we also know will need significant amounts of advocacy and support for.
Yeah, absolutely. Sorry, Senator Shoebridge, we can, unless Mr. Zappier's got any questions about prisons, we can probably move off for the time being to your next issue.
Well, I suppose my only other question on prisons is, if you want to provide the wraparound services in prisons, that's really hard, because there's often very clearly defined ways in which lawyers can get access. There's rooms set aside, there's procedures set aside, but you have to go through a whole other booking process if you want to have a non-lawyer. Mm-hmm. Is that working anywhere?
That's correct. That does have to happen, and we're doing that in South Australia at the moment as well. we're getting access to 2 prisons there, and it's not only our lawyers, but our Aboriginal engagement advisors are going in, and also our financial counsellors as well. Now, that's on the interface with the client, but the concern is what happens when we're not there and what type of support mechanisms are offered to the individual.
Yeah. During the Royal Commission, we were able to, as part of the team out of Queensland that did a significant amount of actual in-facility support. So we would set up and run, in effect, a multidisciplinary legal clinic, and that was one way that we were able to work around some of those challenges. So we were a multidisciplinary team that went in and gave people their advice on the day.
You put the lawyer's cloak around the counsellor and the finance thing, and you walk in.
And everyone was happy. So we got access that way. But again, as you'd appreciate, that's resource intensive, and there's over 100 facilities across Australia. So we don't anticipate us being in a place to be able to offer that option. Having said that, if we can, and we have like a critical mass, which we probably expect will happen in some facilities, certainly in New South Wales, there are particular centres that we see large numbers, also in Queensland. So it may be that that's an option that we can run, but there won't be capacity for us to do that across the board.
No. All right. Then going to the class action, can you describe as simply as you can what the nature of the claim is that's been brought against you?
So, Rachel, we may get you to respond to that.
Yeah. The class action is saying that we have failed to properly advise people on their civil rights. They're saying that we should be giving advice to people about what quantum they might expect to get in a civil claim. And they even go as far as to say that we should actually be representing those people in civil claims. It's of particular note with redress in that when people accept redress, they sign away their right to a civil claim. So essentially they're saying that we've failed to advise properly and that people have signed their redress acceptance documents and therefore signed away their right to either making a civil claim, a new civil claim, or going back to a previous civil claim that they have settled and reopening that deed of settlement. It does seem that the cases that they're bringing are in the category of people who have had a prior civil settlement come to redress with us, and they're saying that they've given away their right to reopen and get more money than they would in redress. We're limited in what we can say about our response to that, but we are obviously well insured, and we have a legal firm acting for us who we intend to defend this vigorously. But the fallout for our clients with media and with other advertisements that this law firm is doing is really distressing for staff and clients alike.
Yeah, and I'm assuming you've raised these concerns with the government, and has there been a useful discussion with the government about what support they can provide and what you need?
Jackie?
We had a discussion with
the beginnings
DSS and AGD.
Yeah. Sorry, Rachel. Yeah. So there's the beginnings of conversations around what might be necessary.
Yep. Could I just ask you for a frank assessment of is there any concern that if this claim continues and maybe if they're out there actively building a class action, is it getting to the point where it may put at jeopardy the ongoing ability of No More to provide services?
So I'll answer that, Rachel.
Yeah.
It's No More's going to continue to provide services, right now, and it's important that all survivors know that the options for legal support are available and continue to be available. For us, the broader concerns aren't about no more, Senator. They're about the broader scheme and the options for redress, full stop, and I guess what it means for, this type of advice to not be part of a broader scheme potentially for the future.
The difficulty is, of course, no more is funded to provide advice on the scheme and statutory entitlements, and it would be a potentially substantially bigger task to also provide and you've never been funded to, also provide a second guess on what a potential non-statutory civil claim would produce. And that your funding model hasn't permitted that, really, has it?
The funding model explicitly denies us the opportunity to provide that.
Yeah.
It sits well outside of the scope of what we're funded to deliver.
Are you in a position? Is that put in black and white in the funding agreement? The exclusion of providing civil advice?
I'm looking at...
I don't believe that it's spelt out in that with that level of certainty. Jackie?
It's not within the contract itself. It sits in, other documentation, etc.
Would you be in a position to take on notice, providing us with details about how that came to be and the constraints around your services that arise from whether it's the funding agreement itself or it's the other arrangements and understandings that are attached to the funding agreement?
We can certainly do that, yes. And just to be clear, I guess it's in the broader conversations and context rather than specific, right, what's specifically written. But we'll pull together what we have that might be of use to the committee.
Yeah. It is a next to impossible situation, though, for a community legal centre who you're not in a position to charge your clients. You're entirely dependent upon a stream of government funding, and if the government funding prohibits you from providing a level of advice or a form of advice, it puts you in a next to impossible situation, doesn't it?
It does, and it's also an issue that we know is of keen interest to the broader CLC and public legal assistance sector.
Yeah, and I'm assuming there's ongoing conversations. Have you had conversations because of that impact on the broader CLC sector, are you having active conversations with the Attorney General's Department about the impact that such a case might have on the broader CLC sector, which all operate with extreme resource constraints in the advice they give people?
Certainly raised our concerns with regards to that with the Attorney General's office, and with the Attorney General.
I mean, I'm not suggesting that there would be a different duty of care depending upon the nature of the lawyer, but it's surely within our legal system, the Attorney General's Department should be engaging with the issues about the nature of the duty of care, the extent of that, the reasonable amount of advice you could be providing. That's actually a potentially systemic risk to legal aid, to community legal services, well beyond this case, isn't it? That's a potential systemic risk.
And to redress support services, Senator, as well.
Yeah. Is there anything else you wanted to put on the record about that, about the potential class action that we haven't covered in this exchange?
No, I don't think so at this point.
Yeah. Could I just finish with what's the sort of time frame for it, as you understand it?
Would you like me to answer that, Jackie? We spoke to our lawyers earlier in the week, Senator, and they're looking at, if the matter does go to hearing, a hearing either in late 2025 or early 2026, potentially a mediation in the first half of 2025. It's a long process, and they could only give us estimates.
And then, can I also just put on the record, on the other side of this claim, putting to one side the lawyers and whoever's running the claim, on the other side of this claim are people who have been the subject of, institutional child sexual abuse. And I am quite certain that No More does not want to be in a position to be, running legal cases against those former clients. I mean, even though you're brought there as a defendant, I'm quite sure that you don't want to be in that situation, and it must be tough for you. And also, I'm sure all of you are very mindful of the that on the other side of the claim is a survivor of institutional child sexual abuse, and
that sits with us heavily and often. Yeah. And I think but the reality is that people also have a right, even if we don't necessarily agree with the situation we find ourselves in, but we've always maintained that survivors have a right to know what their options are and to take up those options. And, that's what some of these claimants are choosing to do, and we respect that. What we do really want to continue to say, though, and going back to opening comments, that, we've assisted more than 25,000 people since we started in 2013. And we remain really proud of what we've been able to do to help so many. But also we want to make sure that anyone that's listening in today also, understands that we continue to be here to help, and, the service continues. People can still call us and we can still help.
And I'm sure, like a number of other members on the committee, my office has had multiple, I can't tell you how many people contact us who have been through the scheme, and I can't say that nobody has ever had any criticism of No More. I don't think that would be accurate.
No.
But the overwhelming feedback I've had from people who have contacted me who have been through No More has been one of gratitude for your for the way in which you deliver your service. So I just would like that on the record.
Thank you very much.
Thank
you. Mr. Zapier.
Thank you, Chair. Mr. Oliver, earlier on you said that there was some 10,000 applications on hold. Were they just general applications, or were they prison applications?
Prison applications that have been held by DSS, and DSS are looking at them being referred out to the network, and some to No More as well.
Okay, so they've been on hold because DSS is going through them and then...
And waiting for the amendments to come up as well, the amendments that were passed in the Senate last year. So there's now a process for them to be dealt with, yes.
Rachel, might you speak just briefly to why applications can be put on hold, and specifically why that would happen for people in prison?
Yeah.
Because the law previously only allowed people in prison to make an application, or for their application to be processed, if they were going to be in jail past the life of the scheme, or if they were terminally ill or with other extreme exceptional circumstances. And so people who made those applications who didn't... Is that better?
Yeah.
I'll speak a bit closer, I'll speak louder.
It's a bit, broken.
That's okay. Maybe I can give a...
Sorry.
I'll give a clunky social work explanation to what Rachel would have otherwise said very eloquently. But basically, that there's, as you will know from the amendments, that there was fairly limited opportunities for people in prisons to apply. But that being said, lots of people still did. they put up applications so the scheme could put them on hold because they give people that option. So to say you're not currently eligible, you may be in the future, we can basically put it on pause for you. What we also know from the number that are on hold is that generally speaking, and as you would expect for people in prison that either have issues with literacy or they don't have someone to help them put those applications together, we know that the vast majority of them are of a fairly low standard and will need a significant amount of work to get them to the standard that they need to be able to be processed by the scheme. So that's why we expect that there'll be a significant number that'll be referred through to us and the redress support service system.
And if your funding does not continue beyond 24-25 to the level that it does, is it your view that a lot of those cases will actually be dealt with in a period where you don't have the funds to support them?
That's certainly a scenario that's possible, yes.
Was that put to the government at any time? That, given the changes to the law that allows the people in prison to now apply, that the cut-off period appears to... Was it any consideration that was given to extending the cut-off period for funding?
We certainly advocated for our funding position to be ongoing, and like I said, we were really pleased to get the additional resources that we did. But what we were presented with was for 12 months. Yeah. So we unfortunately find ourselves again in a similar position of needing to be advocating again around what will actually be a more significant funding cliff now for us of 75%.
And if you don't get that funding, who will deal with the cases? Who do you expect might deal with those
I guess
cases?
we just want to stress there is that we've got a broader redress support service system that's already saturated. We know that even when we refer people out, they're going out and, sometimes waiting, 9, 12 months isn't uncommon either. We remain concerned and want to advocate on behalf of the broader service system, us, the redress support services, because, we know that there's, like Gary said, there's these 10,000 people that are sitting there, plus there's, we know 200 calls a day, coming into the scheme. So we know that there's all the, and that's just people in prison. That doesn't even include the regular community members that are applying. So it is a service system that is already saturated and additional resources being welcome, but I don't think it's anywhere near enough.
Is it likely that some of those people, from your interaction with them so far, would actually just drop their pursuit of redress?
We see different...
That's a very strong possibility.
Mm. Yeah.
Mr Zapier, we know that the more complex this goes, the more triggering it is for people that already feel like they've been abused by institutions. It feels like, another system that's letting them down. And it's one of the reasons that, ensuring that help and support are available is absolutely critical as part of redress, as part of healing, rather than just compensation.
Yeah. Okay, Chair, that's probably all I've got for the time being. I did want to ask about the case against you, but it's probably not something that we should be discussing publicly. So my questions would have gone to matters that I don't think you would want to talk about, the issues that I wanted to raise.
Okay, Thank you.
Thanks, Mr Zapier. I just want to go sort of down a different track if you can. I'm just wondering if you've been noticing any trends in relation to the reasons why redress applications are found ineligible. Anybody can answer me.
Do you want to? Sean will speak to that.
Sure. Thanks.
It's not necessarily a difference in specific reasons that are given, and that's part of the problem in that due to ongoing issues with transparency with the National Redress Scheme, we're often not clear of the specific reason that an application has been rejected. But we are concerned, just anecdotally, that there seems to be a tightening of which applications get approved and which don't. And so we're particularly concerned with applications being rejected that don't appear to reflect a proper understanding of the legal standard of proof. The standard of proof for redress is, of course, the reasonable likelihood test. It's a more straightforward standard to meet than the civil or the criminal standard. And yet we see reasons come back that we, first of all, struggle to interpret, but insofar as we can interpret them, they appear to be rejecting redress on the basis that the survivor hasn't provided specific details about the matter or hasn't disproved alternative situations, which is not something that we can reconcile with the reasonable likelihood standard of proof. And we also see just offensive statements included in statements of reasons that don't reflect an understanding of the nature of child sexual abuse. And certainly for anyone that had read the Royal Commission reports, it would be clear that some of the statements included in the statements of reasons are not appropriate.
Have you talked to the department about these concerns?
So I do know that a number of them result in applications for internal review of the particular matters. They sometimes result in complaints about the particular matters as well. In terms of high-level conversations with the department, Rachel might be better placed to speak to that.
We do raise... can everyone hear me now? I think I've got a bit more connectivity. Yes, we do raise those as either complaints with the department, and they're dealt with as complaints, but that complaints process can't lead to a different outcome for survivors. We're working within a narrow system of one review and then of extremely narrow potential for a judicial review. Go ahead.
It's also very much a case by case, is my observation. So our opportunity to deal with it systemically is, quite limited, which continues to be a frustration.
I mean, we heard evidence earlier today from a witness who had been abused in a school by a teacher, but he'd been offered, made an offer which he didn't think was enough, but when he got his documents back, it said institutional, NA, and we're all sort of struggling. Like, if it happened in a school by a teacher, how can they put that? We hear lots of stories. We have lots of conversations with people about their concerns about transparency and fairness. And I know we've asked you this before, but I'm going to ask you this again. What would you like to see? If you were heading up redress, what processes would you change? And maybe even, how would you change them to make things more equitable?
There was a range of recommendations arising from the second year review that were intended to improve consistency and integrity of decision-making with the National Redress Scheme. I'd need a moment just to review the list of them, but there's quite a few that haven't been implemented, and the first step would be to implement those recommendations. Yeah.
Would you know what you would make as a priority, for example? Take the time. You've got some time, Sean. So,
while Sean's doing that, I think you've raised a really important example, Senator, and I think, as we've certainly seen the incredible distress that can come from outcomes and what's in an outcomes letter itself. And, for survivors, so much of what they want is that, it's even beyond, there's often a lot of focus in how we discuss this about, components of redress. The reality is that, the acknowledgement of responsibility and, an institution being found responsible and how that's conveyed is, remains critically important to a survivor. That's what they're seeking, is that acknowledgement. And, I've certainly worked with some people that have become suicidal because an institution, one of a number of, was not found to be responsible for what, they know happened to them. And even though they got a really significant redress payment, for them, they completely spiralled because of that, that process. And I think that's, that's often the reality of, no one person's what they're seeking from a whole of justice making process will ever be the same. And Yeah. Sean, have you found what you wanted to talk to?
Oh, yeah, just to speak at, I suppose, the legislative and policy level, there's 8 recommendations from the second year review that are intended to address the issues around transparency and integrity in the scheme. And I think a really high priority among those would be publishing the assessment material so that it's transparent what criteria are relied upon in order to implement the legislative framework, and that it's not simply an assertion by the decision maker at the point that we receive reasons, but is something that we can actually interpret legally, advise about and challenge if needed.
And what about the other recommendations?
We would support all of them. We think that they're all very important. But just to provide an example of one that would be a very high priority would be the publication of those materials.
Sure. Yeah. And what about the process around the implementation of those recommendations? What have you got to say about that?
There's a real lack of transparency around the implementation of the recommendations. The Australian government provided its final response to the second year review, which expressed support for many recommendations, but didn't necessarily commit to specific action to implement them. And so it's not clear from our point of view whether further action is intended to be taken. And we do see, for example, ongoing issues around the quality of decision-making and reasons. And we really would like to know precisely what action has been taken to address it and what further action is intended, because the current state of affairs is one where survivors continue to miss out on the redress that they're legally entitled to and to experience re-traumatisation in the process.
Yeah. If I could speak more to that, Sean, I think that quality of decision-making and lack of consistency in decision-making is really seemed to have been addressed, and we were told by the department that they put in place a chief IDM system, but we could never quite, we haven't quite been able to understand exactly what that means, whether it's a form of quality control or whether it's just a training body. And we've asked to meet with the chief IDM, and we haven't been successful in that, so that we could have a dialogue. What happens is that on a case-by-case basis, where there are sometimes really offensive comments made by IDMs in their statements of reasons, we raise those, and the response is often that they will train the IDMs on particular issues. But in all of those cases, the horse has already bolted. The
damage is done.
The damage is done. That's exactly right. We would like something to be put in place that is preemptive of those situations arising.
Yeah. Are you able to? And obviously, you'd need to redact people's names and things, but send us some of those. A few examples of those sorts of comments that people are getting. Have you got some copies of that, or? Obviously, I don't want to identify anybody that it was sent to, but I think if we can actually show the department that this is what's being done, that puts them more on the spot, to be honest.
Senator, in the...
We can...
sorry, Rachel, did you want to go?
No, Sean, you go, please, yeah.
Oh, I was just going to say, as an interim solution, we do have some case studies in the supplementary submission. So, for example,
I'll reread that.
Yeah, page 15. It is quite a long one, so it might be helpful for me to flag where. But page 15 includes quite a detailed case study that a survivor has bravely shared of some really offensive comments that were made in finding that survivor ineligible for redress. And we can speak further with that survivor to see if we can obtain instructions to share the statement of reasons.
Well, Chair, could
I'm just reading it now.
Yeah, could I just ask a couple of things flowing from that? Is that possible?
Absolutely.
Yeah. I mean, I appreciate your optimism that the department will change as a result of those case studies. But I mean, we had a witness this morning where she was again the subject of deeply inappropriate commentary within the department, messaging between themselves about her conduct, her tone, in circumstances where they accepted that she'd been the subject of appalling levels of abuse, and so just stopping there, it's inconceivable to me that they could have dealt with her in the way they did in the private messages. But then they then also rejected her claim on the basis that her family had surrendered her into the state's care rather than being the subject of a court order going into state's care, which on my reading of the Act is not a proper basis on which to deny redress. And we're talking about a recent claim. So yes, you express the optimism that by being shown these examples, they will change, but you've included in your submission, from the evidence we had this morning, that hasn't changed.
And we would like to see legislative intervention, for example, to require the publication of the assessment materials. So more than simply requiring on cultural change within the department, that does need to happen. But as you say, Senator, it's not enough to wait for it to happen.
And indeed, from my observation, the layers of statutory secrecy that apply to this scheme are almost permissive of a culture that cannot treat, almost permissive of a culture that fails to treat survivors, deeply traumatised survivors, with the respect that I think, and I probably think every fair-minded person thinks they should get. The secrecy is actually part of the problem, isn't it?
It replicates the abuse experience. It is walking in the shadow of the perpetrator when a system replicates, those same dynamics, and that's why it can become incredibly triggering for survivors when you're not given reasons why a decision's made, when you can't see the information, when how can you build trust, and then at its worst it re-abuses.
We just this morning we heard from two survivors who both had their claims rejected, and both of them were basically cold called. They had no support. They were cold called. One of them was walking in the paddock with her daughter, and she gets a cold call from Redress after, I think, more than 14 months, where she'd been led along a pathway to believe that her claim was going to be accepted. And she gets a cold call in the paddock with her daughter saying it's been rejected. And her life went in a not unpredictable spiral after that. I mean, you couldn't call that trauma-informed, could you?
No. Not at all. And there's no, we would never ever sit here and defend that. We would only stand alongside anyone that had that terrible experience.
But aren't there meant to be procedures in place for the department so that they don't cold call somebody with a rejection claim? Surely there's.
I think that's more a question for the department than the jury.
Well, but no more may know what the process is as you've experienced it in the thousands and thousands of claims. If they're going to reject one of your client's claims, do they just call them up cold?
Rachel, you might speak to that. Yeah.
They don't. Where there's a nominee in place, and we've been very clear that we're to be the first point of contact, they generally will speak to us first. And having said that, there's certainly been cases where if they can't get hold of us for a period of time, maybe 48 hours, they will cold call the client, and people definitely fall through the cracks there. But where people don't have a nominee arrangement in place, we've definitely heard many cases like you've just described, Senator, where they are cold called and given the bad news straight away. Where we are told ahead of time that there's an outcome pending, we set down a time to call the client, say that there's an outcome, but often we're not able to find out what that outcome is. They say that they're not allowed to tell us ahead of time. Some workers we're able to ask, is the person eligible? And if they can confirm that they're eligible, then we can proceed on the basis that they're not going to get that bad news. But it's difficult. The department did have process in place for a while there where people were told of a preliminary decision of ineligibility and given the opportunity to put more information to the scheme. But that only happens in limited circumstances now. So there are certainly still people who are getting those calls out of the blue to be told, like you say, 14 months in, that they're not eligible.
Well, I mean, I can't understand that. If you've read any of the Royal Commission's reports, if you read anything about trauma-informed services, the idea that we would be permitting a Commonwealth scheme to be calling up traumatised people and telling them without any preparation, without any support services, that their claim has been denied, I find that intolerable. And it's obviously not a matter that we would address with you, but I think we should, as a committee, address it with the redress scheme as a matter of urgency. And can I... The second witness we had this morning who had this experience was a woman now in her late 60s who was sexually abused in what purported to be a medical procedure, tied down against her will, brutally assaulted, left bleeding and in pain by a person she thinks was probably a doctor who repeatedly insulted her in the course of doing that procedure, that assault. She finally gets the courage to bring the claim, and then she had that claim rejected in a cold call phone call where she was told it was a medical procedure. And she says that it just knocked her sideways, as of course it would. Of course it would. So I just might ask you specifically on medical procedures. We've had multiple witnesses give us evidence about this. We've had people contemporaneously saying that they knew it was wrong and they knew there was no bona fide basis for it, but their claims are still being rejected. What's No More's experience?
Rachel?
Our experience is exactly that. That
can I say it's rare that I want to swear, but insert your adjective of choice, shameful that the department is doing this to women. And we've had the evidence, and they made certain representations that I thought that they had changed. And the fact that they haven't and they're still doing to this is beyond reprehensible. Sorry, Rachel.
No, that's fine. Yes, we definitely still see those decisions coming back. There are some that we do extensive submissions on and really focus on the survivor's subjective experience of that assault that maybe do get through. But the changes that I understand the department said they were making with respect to medical procedures was, again, an internal policy decision or document, and we've been unable to access that through due to the protected information provisions.
Which is where we go back to this issue of transparency, the lack of transparency, and also because it continues that, our only options are often to take stuff up on a case by case. Mm-hmm. So our ability to meaningfully influence those issues when we see broader patterns is remains limited.
And just to be clear, it's my understanding that despite those protestations from the department, nothing has changed apart from that document you referred to, and that is none of that has responded to the evidence and concerns this committee has seen. None of it. Mm.
I just want to bring up that issue around protected information that Rachel, you mentioned, I think. Obviously, that leads to a lack of transparency around any decision and any outcome. How can we protect information provisions, or how can protected information provisions be improved so that there's more transparency around decisions, but at the same time doing that balancing act of maintaining adequate protections for the sensitive information. Have you got any suggestions for us, is what I'm asking, really?
Rachel, do you want me to come in on that one?
Yeah, thanks, Sean.
Yeah, that's okay. Thank you, Senator. There's really two levels to the problem with protected information. And the first level to the problem is that we consider that the existing provisions authorise far greater disclosure of information to survivors than is presently taking place. Because while much information under the scheme is protected, there's also broad exceptions. For example, there's exceptions to disclose information for the purpose of the scheme, and we'd argue that providing adequate reasons to survivors, for example, is a purpose of the scheme. And there's also exceptions for the express or implied consent of the person or institution to which the information relates. And so there's situations where there might be implied consent to release information or where express consent could be sought. So the first step to addressing the problem with protected information would actually just to be to carry out the current legislative framework. But there's also amendments to the legislative framework that could be made to improve how protected information operates under the National Redress Scheme. And we've made some detailed comments about that in our primary submission to the committee. The reason I'm referring back to the document is just that protected information is a really complex area, and our view is that the reform can't be piecemeal, that it does need to take stock of all the different purposes that information is used for. It does need to balance the fact that survivors need adequate information, but survivors also need to have confidence that their own information will be protected and that their confidentiality will be respected. Yeah. But for example, there could be amendments to the Act to require the NRS to provide more information or to provide reasons when it chooses to withhold information.
Thanks. Has anyone else got any questions, or is there anything else that anyone from No More wants to add before we finish?
Chair, can I just ask this question? It gets back to the notification process. And we heard earlier on that where No More is handling or supporting a particular application, that often No More will be advised in advance of what that would be. Is the advice by telephone or in writing? And secondly, if a final decision is made, is No More also included in the advice, in the written advice that's provided?
Rachel?
Yes. We are, in terms of us being told ahead of time where we are able to get that information, that would be by telephone. Okay. And where we're a nominee, we will always seek to be a part of that outcome call where the decision is delivered, and we're CC'd into any documentation. So the offer documents, which now include a statement of reasons, but the quality of those statement of reasons is not always what we would like in terms of the detail in it. But like I said earlier, there are certainly situations where people, I guess, fall through the cracks and we're not included on those outcome calls. And that can be really, really confronting and distressing for people, even if they get an outcome that might be considered to be a good outcome, to not have the support of their lawyer who's walked them through the entire process is a really difficult process for them.
Yeah.
Is that did I answer?
Yeah, no, you did. Could I ask you this question? Do you believe it's appropriate to notify anyone of a decision in respect to an application by telephone?
Answer that one, Rachel.
Thanks, Jackie.
It might be appropriate, Senator, if the meeting's been set up in advance. So sometimes survivors might choose that that's the best way for them to receive the advice. What shouldn't happen is the cold calling. So there should always be some form of communication first that explains that an outcome's been reached and seeks to set up a time to deliver that outcome, not to just do it in the first communication.
And is the person who makes the telephone call, to your knowledge, the person who has actually made the decision, or is it someone
No.
else?
No.
I'd be surprised.
It's someone else.
It's someone else.
So
and
yeah, it's a
it's removal of knowledge around the decision.
the person who makes the decision, they're not identified in the decision or the statement of reasons. They hand it back to the department once they've made their decision, and it's delivered by a worker. And to be honest, there's definitely there can be a wide variety in terms of the sensitivity with which those outcomes are delivered by staff. Yeah.
And lastly, is the decision maker ever identified?
No, they're not. Never. We know, we can see on the website the CVs of all of the decision makers, but they're never identified, ever.
Sorry, just one last question on that. In the process of assessing the application, is it ever the case that the decision maker wants further information? And if they do, how do they seek it? Do they make contact, or do they get someone from the department to make contact with the applicant?
Firstly, that does happen, that they ask for further detail, further information, but they don't make any contact. That is done by a department officer. Okay.
So we have a go-between, effectively, between the person who's making the assessment and the applicant in terms of trying to provide additional information that might be required. Yeah.
This is again where us being a support service and the redress. So where we are a nominee is we can again that's those, so not expecting those kind of out of the blue jolts. Yeah. And we also know that approximately 20% of people that navigate the NRS process do so with formal support, and the rest do it on their own, and that's why we want to continue to, encourage people to access services like ours, like the redress support services, so that we can be that buffer. Yeah. That is what a trauma-informed approach is.
Yeah. No, thanks for that. I'm just trying to get my head clearly around the step-by-step process that takes place. So thank you.
And if I could add to that, unfortunately, since the demand for our services have risen, we've had to pull back on doing that full wraparound service for as many people as we have in the past. While the funding this year is really welcome, as we've said, there's no guarantee of that past this financial year. So we may well be in this situation in a year's time where we can't provide that wraparound service for most people.
Yeah. No, understand.
Chair, could I just ask one?
Senator Shoebridge, yeah. I see you moving as though you've got a question.
No, I do. The fact that there aren't even consistent acronyms or some kind of consistent identifier for decision makers means that there's no capacity for any external entity to try and get some accountability, where you may have a particular decision maker who routinely dismisses, routinely makes errors, routinely is overturned on appeal. You would have thought that they could retain the anonymity of decision makers if they assume that there's a systemic good for that, no question it, but they could retain the anonymity of decision makers but still allow for a degree of accountability by at least giving that consistency and that consistent messaging, couldn't they?
My understanding is that Oh, sorry, Rachel.
No, go, Sean.
I was just going to say that the establishment of a chief IDM was, my understanding is that was intended to go towards that purpose. And Rachel may be able to help me out here, but my understanding as well is that what has been implemented is instead a panel of chief IDMs rather than a singular person. And so the individual accountability again disappears.
Yeah, and if someone can tell me what the chief IDM panel does, I'd be really appreciative.
That's what I said.
Yeah.
Yeah, and look, that's they're the technical aspects of it. The reality is that we know that what survivors demand and expect, and the only way that they will ever feel that they access justice through these processes is to have that transparency, because otherwise it's a nameless, faceless person making a decision about them that has lifelong consequences, and we stand alongside that not being okay.
And I suppose this is a question for redress, but I wonder if they understand the impact of a denied claim and the re-traumatising nature of a denial of a claim. Because as I said, we had just 2 cases this morning where both of those women had their life knocked sideways because of a denial of a claim. And it's almost as though that was just white noise to the scheme. It was irrelevant to them. They'd done their statutory function and they just delivered an outcome, and whatever the impact of it was irrelevant to the scheme. And it was hard to watch this morning.
There's often such a process, as we know, that people go through in even making that bold decision to come forward and want to, speak about what's happened to them in the first place. And, we know the Royal Commission found that took more than 20 years on average for someone to even talk about it for the first time, let alone have the bravery and courage to want to step through, a process like redress. We also know, we continue to observe the gendered nature of applications through the scheme. So even though we know that there's more men coming forward than women, when you hear examples that you're sharing from evidence this morning, we also know that there are so many other complexities often for women in even reconciling that abuse has occurred or what they have lived with for so long fits in that category. And then to come forward and have that bravery and then to have such an outcome, I can only imagine how incredibly devastating that is. It also exposes a significant gap in the service system, which is what happens for people after redress. Even though we can talk to people, they get an outcome, what happens to people that navigate that process for 14 months, then are told they're ineligible. Where do they go? Where do they go for help? That is of interest to us. But also, we have people that contact us for years afterwards because they're continuing to process their experience post-redress, because there can be an initial high often, and then, sometimes then people can, crash again. It doesn't change what's happened to you. You continue to want to integrate, your justice-making process through the course of your lifetime. So, those are important things. We know there's a counselling component, and that goes some way to helping people do that if they choose to pick that up. But the reality is this is a lifelong journey for survivors, and, there continues to be a responsibility to help them, integrate that as best they can and move towards some level of recovery.
Can I also just say that, in no way to excuse the behaviour that was associated with the ineligibility situations this morning. Rachel spoke about the variability of the way messages are delivered, and it is fair to say that I have seen some delivered with infinite care, and I do want to acknowledge that as well. As I said, it doesn't take away from the experiences of survivors this morning, and frankly, I don't know that there's any way to say it nicely, but there are certainly people within the scheme who do it better than others.
Well, if you know what you're going to deliver is potentially re-traumatising, and you think it's at all reasonable to do it without any prior notice, without a support person there, and without, at a minimum, providing in an accessible way a bunch of alternate supports, then
and without any empathy.
Without any empathy, then I I accept what you say, that the information will never be well received, but for an organisation that pretends to be trauma informed, that's inexcusable.
On that note, unless you've got any more questions, we might end with no more. Can I thank you all very much for appearing today. Jackie, I hope you're feeling better very, very soon.
Thank you, Senator.
If you've been asked to provide any additional information, please forward to the Secretariat by Thursday, the 15th of August 2024. There will be a transcript of the evidence sent, and there'll be an opportunity for you to request corrections to any transcription errors. And I think at this stage, after a 5-minute break, committee members should rejoin using WebEx link 3. I think I'm the only one on WebEx at the minute now, aren't I? So we will briefly suspend. Thank you again, not only for today, but for your submissions and the great work you've been doing out there trying to support these people. So thanks very much. We'll suspend and resume at 3:25. meeting has resumed. Before we begin, can I just clarify whether you would like to give your evidence in public, Glenn?
Yes, please. Thank you. Yeah.
Sorry, I can't hear you.
Yes. Hello?
Thank you.
Yeah, thank you.
Yeah, you just need to speak a bit closer to the microphone, so maybe put it down a bit or up a bit for you, so make it a bit easier. Yeah, great. Look, my apologies for not being there in person. I've had some medical issues and so I'm not allowed to fly this week, but thank you for appearing.
Thanks for having me.
Okay. For the Hansard record, would you like to state your name and the capacity in which you appear before the committee today?
Yeah. My name is Glenn John Higgins. I'm in the capacity as someone who has engaged the Royal Commission of Institutionalised Child Sex Abuse and No More, and obviously going through the redress program as well.
Lovely, thank you. Where are we at? This hearing is a legal proceeding of the Parliament. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. So I now invite you to make a short opening statement of no more than 5 minutes before we proceed to discussion.
Can I, sorry, is it possible if I can just do that a little bit later, or like...
What's that?
The statement?
Do you want to tell us your story, or?
Okay.
How do you want to proceed? You tell me.
Right. Okay. Yeah. I guess I'll do part of the statement now. So.
Okay. Lovely.
I guess for myself, I have probably an unusual engagement with the Royal Commission and No More, as I had multiple perpetrators growing up, and some did not fit the terms of reference. One didn't fit the terms of reference and the other did. The one that did not, I actually had taken to court in the 90s and went all the way to the Supreme Court where there was a conviction. So I guess I come from the background of basically having gone through the court system as a child and then obviously engaging redress at a later date. The reason being that the second perpetrator has basically, how do I describe it? Where I've engaged process to try and find some element of justice was because he was the counsellor for me while I was going to court. So obviously, I guess that kind of presents a sort of a difficult situation for me at the time, where it was I just wanted to report one and two would blow everyone's mind. Now, I guess with No More and the Royal Commission has been interesting to engage. I guess with No More, how do I describe it? Firstly, I did 102 sessions of trauma therapy before I actually went to No More. So I did the therapy first. Then obviously had a preliminary, made a preliminary statement, got preliminary advice, which was all over the shop, I guess. It's been difficult to engage them because I
am still dealing with repercussions from the first perpetrator, shall we say, legally. And so that made things quite difficult in regards to dealing with No More, because I was very difficult to handle, obviously. And so I ended up having to press pause on my redress application, which was quite difficult because it's to press pause on an application is they just found it hard to grasp. It's like, you know, I wanted to be signed on, but I just can't commit to it emotionally, psychologically right now. I found that going through the other legal process was very, very, very traumatic. And so there wasn't a lot of understanding on the side of No More. It doesn't quite accept that you might have ongoing legal issues. Another thing too is that as my family, I guess, reacted in a particular way in regards to the first perpetrator, because it went to the Supreme Court, I had to testify. There was a conviction. He was a family friend. There was like a social fallout and all this sort of thing. And they weren't keen for me to go through the same situation. So they disposed of the evidence, which they'd hung on to for 27 years. And that made things difficult in regards to, I guess, the legal process, where I'm a little bit younger than most people that have probably fronted. And so in some instances there is evidence still around. And it's very difficult when your family member basically goes, we'll just throw it away, we'll forget about it. And so that does make things difficult. I found out about things like Section 6K of the Royal Commission Act of Disposing of Evidence. And obviously I made inquiries to No More in regards to is this applicable to I guess, to my case, how No More handles that. And there wasn't a lot of information sort of forthcoming. And so finding out now that it's kind of a line of inquiry that you do with the AFP, and also too, I don't think there's actually been a conviction under Section 6 of the Royal Commission Act, which is quite illuminating. I can, if someone can correct me on that, but I haven't found anything. Which obviously, I'm sort of a former public servant who's kind of a bit of a stickler for legislation at times, and so I've been hung up on the disposal of evidence in regards to how does that get remedied? How I think as well as it as in my statement, it's the actually No More. It just handles cases differently from people who are younger. It's the laws obviously have changed now in the course of the Royal Commission and the time after it, which opens up civil proceedings. But I mean, I can't get over the fact that because I engaged the Royal Commission was the reason why the evidence was disposed of. That's kind of hard for me to comprehend, I guess. It was silly of me to even tell my family that I was actually engaged in the Royal Commission. I didn't expect their reaction. But it's, obviously that it makes it interesting now for a civil and criminal case. It took me 3 months of trauma therapy just to get on the phone to sign up to the Royal Commission, considering all the, dare I say, all the shit that I went through court and as a child. And, you know, back in the 90s in Western Australia, there were hardly any convictions. So, you know, and there's fallout in the community, to say the least, especially, I guess, their people's opinions. So I've basically lost evidence for a criminal conviction. And I think sort of there wasn't like an appropriate handover between, I guess, the therapist to know more as well, because I said, I have evidence. I know that it was being hung on to. And so, but there wasn't a dialogue between the therapist and the legal entity, because once again, it's like I'm a bit younger, and people couldn't quite wrap their head around it. That there might be evidence about. So obviously, I signed up to the Royal Commission for criminal proceedings, because knowing what I've gone through before, it's like I want a criminal conviction. It's as simple as that. It has been So how they responded is probably not the best. I did attach a document in regards to a discussion paper from the Attorney General's Department in regards to trauma-informed legal services. And it's just, for someone like myself, it's just a great idea, but it's just a little bit too late for me, obviously, with my situation. And yeah, I didn't sort of want to. I'm not someone these days who does. I've done my therapy, and I'm still kind of waiting for the dust to settle on that, to say the least. I mean, 102 sessions of trauma therapy is something else, and especially if the therapy's hit and miss, which it was more miss than hit. It's kind of made things a little bit more complicated. Now, yeah, I guess it's a case of I hope something comes from this committee in regards to recommendations on how evidence is handled in a Royal Commission, at the very least. If there is instances, I mean, if there's a therapist has to mandatory report certain things, and if there's evidence for a crime, you'd think they'd do it. So, yeah, it's been very illuminating, and it's sort of I guess the evidence that I've got is gone, and can't even press charges on the family member, essentially. Or I am not. I haven't been in the position to receive advice for that, which is another big step. But that's another big step.
Well, thanks for sharing all that. That's really interesting. First of all, what sort of evidence are you talking about that was destroyed? Are you able to tell us what sort of things?
Just sort of things that this particular person bought for us. So it's one of those things where I had actually been estranged from my family for quite some time, and they'd actually hung on to that evidence as like all the belongings that I left behind. So it was instances where it's like they bought something for like, $300 on their corporate credit card, obviously the institution, and I tried to go back and find, it's like, well, the stuff where it was bought, the store's shut, that sort of thing. I can remember the bank. I can remember the bank where that was on the card, things like that. So it's just sort of instances like that where,
Sounds like grooming.
Yeah. Hindsight's a fucked up thing, but it's obviously an instance of that, and as a postscript to that, it was like that therapist sat on my side of the aisle when I went to court. So I have a very bent view of justice.
Yeah. What would help you?
I'm sorry?
What would help you go through this process? What do you need? What sort of...
I guess I'm used to...
things would make things a bit easier for you?
I don't know anything but a Pyrrhic battle. Unfortunately, that is pathological with me. I just don't know anything else other than the hard way, the hard road. And I guess I think the recommendations from the committee, I just hope they're tangible, insightful, intelligent, they're implemented, and I think whatever comes from the discussion paper as well, I think would be quite pertinent. I have a very unusual relationship with law enforcement dating back to that time. And so I think an avenue to report evidence, I think as well, sometimes law enforcement can be the judge and jury before the judge and jury, and that has to be taken off the table. I'm in no doubt about that. I guess, like, I'm 48 and I'm still fighting these battles.
Yeah.
I've got instances where the first perpetrator is a recidivist, and I basically have had difficulty reporting that. So to say the least. So it's kind of because it's just I'm provoking the police by trying to report recidivism, which is like that boggles my mind. So it's just obviously some of the stories I'm sure that you've heard are harrowing, but there's sometimes, I guess, an element of complexity as well, and what's made...
They're all individual, Glenn.
Yeah.
All the stories we hear, they're all very individual.
Yeah, they are one of one.
Yeah, exactly. Nobody else can really know, I don't believe,
No.
what impact it's had. But this committee is definitely trying to, improve the way that the redress scheme works. So, some of the comments you've made today, I think, have been very informative to us. I'm not sure if Mr. Zapier there has any questions.
Katrine, yeah, just a couple if I can. Glenn, you had a court case that went to the Supreme Court or the High Court.
Supreme Court.
Supreme Court. Was the outcome of that what you were hoping for? Maybe not in every sense, but did you achieve the outcome that was effectively what you were trying to pursue?
Well, that's obviously going through the court process in the 90s was very, very different.
But what was the outcome though? Did that, in other words, were you trying to have this person found guilty, and I assume that was achieved?
Yes. So there was evidence that he had on a computer, and he was into computers at the time in the early 90s. And so the police cracked his computer and found a diary, which was damning evidence. Yeah. So, but essentially he got, how do I describe it? I self-sabotaged the case in my testimony, where I basically said, at the very least, he needs to be on the sex offenders register for life. Yeah. Now,
and was he?
Far from it. Far from it. Okay. So he ended up getting 3 years good behaviour.
Okay, all right. And so is that part of the reason you're not pursuing the redress application, because you have lost confidence in the system?
I tried to go with I did not apply for criminal injuries compensation at the time in the 90s, and so when redress came about, I had an
opportunity.
I had an advocate basically say, we'll try and go the criminal injuries compensation route. And basically that was interesting in the sense of you had to confront the guy in court, which I was too scared to. Yeah. And then I Googled him the night before, for the first time in 27 years, to find that he'd started a little athletics club.
And he's still around doing that?
He did that between 2008 and 2015. There's like photos on Facebook of him cooking food for the parents. Yeah. Now, obviously, seeing that and then getting the compensation, having, I guess, my own mental and cognitive issues, it's been extremely interesting trying to report that. And obviously I found, I guess, instances of stakeholders and their industry partners being quite adversarial. Now, I guess for mine is just, you'd think if the guy's been on a register, that they might like look him up on Facebook.
So just to be clear, the application for redress relates to the actions of this person?
It relates to the second person.
To a second person, which is someone else again?
Yeah.
Oh, okay. And you haven't cancelled that, you haven't dropped it, you just haven't pursued it?
I basically got booted off. I got booted out of No More.
No, out of No More, but No More is not the redress scheme. The redress scheme is still the government-run scheme.
It's still in play. I guess I'm weighing up I'm still trying to report the first one. That's the thing. I'm still trying to report the first one. It's kind of like it's the compensation thing. Is like I've spent my criminal injuries compensation trying to report the first one. That's the thing, and I'm kind of like, and until basically that's been overseen, I sort of redress has kind of fallen by the wayside. But also too is it obviously there's been High Court judgments that have changed things in regards to going down a civil path, and I'm probably too focused on the first person
to worry about the second.
Yeah, I've just found that dealing with No More itself has been off-putting. It's kind of I just because I guess for me, having gone through court to get criminal convictions does leave an indelible mark on how you proceed with these types of cases.
Understand that. Yeah. Thanks, Katrina.
Glenn, I haven't really got any more questions except, have you got any ideas or suggestions for us on what needs to be done to make the process easier for people? The redress system I'm talking about.
Yeah. I think there needs to be a little bit more insight from the, not so much, I think there just needs to be a little bit more truth from the victim survivors that, how do I put it, if it can be made tangible in regards to the process. I think that sort of sometimes it's like advocates have their place and lawyers have their place and they draw up all these nice sort of process maps and things like that, and basically, let's put it this way, there's trauma-informed responses, and I am really yet to see a trauma-informed process. I've tried that just to try and pause things with redress because I'm literally a clown that's juggling lots of issues. But I guess that's the thing, it's not a question from going point A to point B. It's like there are options. There needs to be options in regards to the trauma-informed process. And it needs to be authentic. I think sort of like sometimes meaning well does not mean doing well. And basically it's kind of processes are not unique. How do I put it? They need to be adept to adapt. And you sort of don't really see that a lot. You know, a lot of it is just sort of, and also too, is it to try and have one person to see you the whole way through.
Yeah,
I think
there's been a bit of a lack of consistency with who you speak to in places.
Yeah, I think putting the old public servant hat on, it's like evidence-based practice has. It's not 100% perfect, but also too is it you don't have to repeat yourself again and again and again and again and again.
Yeah, because that's an extra trauma in itself.
Yeah, to the new person, it's just sort of one of those things where. It's like that preliminary advice that you get back from No More. It's like you've got to go through 18 pages or whatever to correct. Seriously? I mean, it's like...
Yeah.
And I think mine's probably a short one.
Now, you said you paused your action with No More, but you can... have them reopen it. You're aware of that, aren't you? If you want to.
I've had some interesting correspondence, I guess, with No More in the sense of, I don't think the door is open as much as you think. It's a case of, like I said, I've just found, if I'm having a bit of a meltdown, there's sort of, sometimes it's not about counselling and all that sort of thing. Sometimes it's just sort of like you need something tangible to fix the cause. Yeah. I'm someone who's absolutely sick and tired of effects and effects management, because you need to see something tangible in regards to the causation that needs to be resolved. And it's like, I try and find that in many ways, because as painful it is to do that, the reward hopefully is just basically that scar might heal a little bit, or at least it has a chance to.
Yeah. Glenn, we've run out of time, and I think Mr. Zappier's probably got a plane to catch. Can I thank you for coming today and for giving evidence?
Yeah.
I know it wasn't easy for you, and we really do appreciate you making that great effort for us. It's been really informative for us.
Yeah.
If you've been asked to provide any additional information, please forward to the Secretariat by Thursday the 15th of August 2024.
Yeah.
You will get sent a transcript of your evidence from today, and you will have an opportunity to request corrections to that to any transcription errors that might arise.
Yeah.
Today's proceedings have now concluded, and the committee is now adjourned. But thanks, Glenn. Thanks so much for coming in.
Thanks very much for having me. Thank you.
Thanks.